Hearing the appeal Enal against Singh and others.
Yes, Mr. Radley Gardner.
My Lords, my Lady, I appear in this matter for the appellant, along with Mr. Ramesh Maharaj, Senior Counsel, who is here through the public link only, observing. You will have seen that on the screen we have for the respondent Mr. Ernest Koilas, Senior Counsel, leading Ms. Debbie Rupchand and Ms. Euclid Koilas.
Can I just check we are coming over loud and clear in Trinidad? Can you hear us? I'm not getting a response. Mr. Koilas, can you hear us?
I am now hearing you. Go ahead.
Thank you. Thank you. Yes, do continue.
Lords, my Lady, this case is a tale of two transfers. There were essentially two issues of law which had to be resolved by Mr. Justice Rahim and then the Court of Appeal. The first relevant transfer was a transfer from 1976, which for the board's note you will find at page 199 of the electronic bundle. And that was a transfer by which the person we can refer to as Ramnarine Maharaj, the late Ramnarine Maharaj, acquired, as stated in that transfer, in his capacity as agent, land including the subject land, the subject of this appeal, which he acquired and transferred into the joint names of his children, being his daughter Shakuntala and his son, the late Ravi Maharaj. So that's the first of the two transfers under consideration. The legal issue that arose in relation to that was whether, in so transferring that property, Ramnarine had passed full legal and beneficial ownership to his two children under the presumption of advancement, or whether, as the appellants contend, that gave rise to a presumption of resulting trust arising on a gratuitous transfer, which presumption was not rebutted. The debate has moved on a little in this appeal because it is now also said that some of the text of this transfer can be said to support a affirmative, positive, donative intent, which I'll have to address the board on. The second transfer was a transfer executed by the late Ramnarine in 2006 in favour of the appellants. He did that pursuant to a power of attorney which he had over Ravi's real estate and property. So those are the two transfers and those are the two legal issues that fell to be decided by the courts below. They are wrapped up in a general point of procedure, which is really, from the appellant's point of view, probably the major point for the board to consider, which is as follows. Mr. Justice Rahim, in his judgment, decided that the presumption of advancement had been rebutted, but that the presumption of resulting trust had not been rebutted, and therefore Ramnarine remained the beneficial owner of the property in question. And secondly, Mr. Justice Rahim decided that there was no undue influence which tainted the 2006 transfer, and that therefore there had been a proper transfer of Ravi's interest in the subject property to the appellants. The Court of Appeal reversed Mr. Justice Rahim on both counts, deciding that, in fact, the presumption of advancement was unrebutted, and secondly, that there had been undue influence and that the 2006 transfer could be set aside. The appellants say that the Court of Appeal wasn't entitled to do any of that. And the reason why the appellants say the Court of Appeal was not entitled to do any of that was that actually, when one analyses the judgments, there was no suggestion that either Mr. Justice Rahim or the Court of Appeal had got any of the law wrong. In fact, there was hardly any controversy about either resulting trusts or the presumption of advancement, and there was some light controversy about undue influence. But what the appellant says, what the Court of Appeal actually did, was to do something that is impermissible, which is to simply reopen the factual analysis and replace the analysis of Mr. Justice Rahim of the primary facts as the trial judge hearing the live witnesses with the Court of Appeal's own simple re-evaluation of the factual material. In that regard, I entirely appreciate that this court, more than probably any other court, will be entirely familiar with all of the principles that are applicable, but simply because they are at the forefront of my submissions, I would very briefly like to take the board to 3 short passages in the Henderson and Foxworth case, which are the lens through which I say the board ought to look at what the Court of Appeal did.
You accept the Court of Appeal cited the correct principles?
The Court of Appeal cited the principles and then, in my respectful submission, proceeded to ignore them. The Court of Appeal identified its limited role in setting aside primary factual determinations by the trial judge, but then did the very thing that they were injuncted not to do by the authority. The 3 short passages that I would like to refer the board to are, as I say, in Henderson, which your lordships and your ladyship will find in the electronic bundle at 767. The 3 paragraphs are, first of all, paragraph 48 of the judgment of Lord Reid, in which Lord Reid explains at letter F that an appellate court is bound...
Which page you on?
I'm so sorry, 782.
Thank you.
And at letter F, towards the end, Lord Reid explains that an appellate court is bound, unless there is a compelling reason to the contrary, to assume that the trial judge has taken the whole of the evidence into his consideration. And he there cites 2 supporting authorities for that. The second passage is at paragraph 57, which is electronic bundle page 785. Which he explains halfway between letters B and C. The trial judge must, of course, consider all the material evidence, although, as I have explained, it need all be discussed in his judgment. The weight which he gives to it is, however, preeminently a matter for him, subject only to the requirement, as I shall shortly explain, that his findings be such as might reasonably be made. An appellate court could therefore set aside a judgment on the basis that the judge failed to give the evidence a balanced consideration only if the judge's conclusion was rationally insupportable. And really that point is made with greater force in the final passage at paragraph 62, which is bundle page 786. There Lord Reid again sets out the test, which is that it has to be shown that the trial judge has gone plainly wrong, and in essence says that what has to have happened is that a conclusion has to have been reached which no reasonable judge could have reached. So it's a Wednesbury-type standard of irrationality that has to be pointed to before the appeal court can interfere with the factual findings of the trial judge. And the point that I won't labour over and over again is that in my respectful submission in each one of those cases, the Court of Appeal did not pay heed to what Lord Reid said an appellate court should do in the Henderson case. With that in mind, I'd like to address the board then on the 2 legal issues that remained live as the case developed through the trial and then into the Court of Appeal. The first issue surrounds the 1976 transfer, which is the relevant transfer by which Ramnarine transferred to Shakuntala, his daughter, and to Ravi, his son.
Well, is it that? Why do you say, wasn't it a purchase from a third party, a company and a liquidator, sold the land to Ravi and his sister? So why do you describe it as a transfer from the father to the children?
Your ladyship is right.
There's this inaccuracy which is, I can understand your point, which is that because the father paid for it, that's how it's alleged the resulting trust arises, but it wasn't a transfer by him. No,
your ladyship is right. The more accurate way or the correct way of explaining it is that what Ramnarine did was to procure, not in a pejorative sense, that there be a transfer from the company in liquidation to his 2 children, but using Ramnarine's funds. And that is a classic instance where equity suspicious of volunteers and suspicious of people getting things free of charge, applies the two evidential presumptions. First of all, the evidential presumption in favour of children, of the presumption of advancement, and then secondly, if that is rebutted on the facts, the presumption of a resulting trust whereby the gratuitous transferor is presumed to have retained the beneficial interest unless evidence to the contrary is shown.
I would say that's a rather old-fashioned approach these days, but it doesn't seem to have involved any controversy in the courts below as to it being the right approach.
No, my lord, and your lordship is right. In some other common law jurisdictions, the presumption of advancement has been abolished. Indeed, here, statute has done some of that too.
I was thinking more of the general tendency of a modern court applying equitable principles to look hard and see what the intention was,
yes,
rather than apply a series of rather old-fashioned mechanical presumptions.
Yes, I think your lordship is right in the sense that these presumptions operate because equity abhors a vacuum. So if there's an evidential vacuum,
yes,
those presumptions step in as a final resort. So my lord, and I will of course then have to address you on the factual matrix around the 1976 conveyance to show where that evidence goes. But that was at any rate not controversial below.
But do you accept that if there is that, what you describe as an evidential vacuum where the presumptions might apply, in this case the presumption of advancement would have rebutted or effectively annulled the presumption of the resulting trust?
The way in which those two presumptions are said to work is that the family relationship of parent and child is the first step of the presumption that's looked at. And if that presumption is not rebutted, the resulting trust doesn't seem to get a look in. It's only if that initial presumption of advancement is rebutted, and I can take your lordship to the authorities, but the modern judicial approach to the presumption of advancement is to regard it as really a rather last-ditch presumption to apply. But if that is rebutted, then the evidential presumption of the presumed resulting trust takes effect, which then in turn can be rebutted by any factual evidence to the contrary.
But if you're involved in an exercise of deciding whether it's rebutted, then really, as my Lord Briggs has said, all you're really doing is looking at the evidence to decide what on the facts is the most likely outcome.
Yes, except that the presumptions only really take one so far, that they give expression to equity's policy, at least the resulting trust presumption, that leans against people alienating property free of charge. So it has that slight evidential, it tips the evidence slightly in that direction.
The other way of looking at it is to assume that equity follows the law and that whoever has the legal estate starts off with the beneficial interest, unless there's something to point in the opposite direction.
My Lord, that is one way of looking at it. The problem is that with that analysis is that is not how equity looks at it. If one looks at, for example, the decision in Westdeutsche Landesbank Gerritsenschale of Lord Brown-Wilkinson's judgment, he explains that the primary evidential presumption, which is all the resulting trust presumption really is that equity leans against the idea that people give away property free of charge. But that can then be rebutted by, in the words of Lord Brown-Wilkinson, any evidence to the contrary. So it's not an irrefutable presumption. It is simply a useful starting point to analyse the evidence according to Westdeutsche and the cases that follow it. So, my Lord, I think what I need to do is set out the background matrix to this 1976 conveyance to show what the material was that was before Mr. Justice Rahim that led him to conclude that the presumption of advancement was rebutted, but that the evidence did not rebut, and in my submission actually went with the grain of the presumption of resulting trust. The starting point here would be first of all, to call to mind the conveyance, first of all, which is, as I've said, at 199. And just to note four general features of it, which I've referred to briefly. First, the transfer wasn't to Ravi alone, but to Ravi and Shakuntala. Secondly, and this is a point that the respondents have placed a little more in the foreground on this appeal before the board, Ramnarine describes himself in the recitals as acting as their agent. Thirdly, the conveyance included not just the subject land, but also additional land. The land that we are disputing, that this appeal concerns, was only split out of that title following a partition action in 1992, to which Ramnarine was not a party, but Shakuntala and Ravi were. And fourthly, the point that I made briefly to my Lady Rose is that it's common ground that Ramnarine funded the entire acquisition. Ramnarine was a successful property developer in this jurisdiction, and one highly material fact which is to be understood in relation to this conveyance is that he adopted a practice of acquiring land in the names of his children and vesting it in them, and then trading it, buying, selling, developing, and so on. The reason why he used his children's names as a repository for the properties he acquired is not entirely clear. In the course of discussions in the transcripts, there is a suggestion there might have been a taxation reason for it, but be that as it may, it is common ground that that was his standard practice, and we can see that in the judgment of Mr. Justice Rahim, which is in the core bundle, but you will also find it electronically, the passages at page 280.
There was no explanation of whether, if it was in fact the case that this was a tax mitigation practice, whether its efficacy to mitigate whatever tax he wanted to mitigate depended on him divesting himself of both the beneficial interest and the legal interest.
That's absolutely correct. All I can say is I've only found a one-line throwaway comment which ends in an ellipsis that says it might have been about tax, ... But what the evidence does show is that Ramnarine bought, sold, traded this property on his own account in his capacity as a property developer.
But not universally?
Not universally.
So there were exceptions to this
There were exceptions. There were two exceptions. The first exception, I should say before I answer that, of course, it's also important to note that both Shakuntala and Ravi were subject to powers of attorney. But there are two exceptions which we know about from the record. Exception one is that certainly in Ravi's power of attorney, they were excluded from the schedule, a series of properties which were not within the province of the power of attorney. And secondly, we also know that on one occasion, Ramnarine made a beneficial gift transfer, which was 37 to 39 High Street, which was was turned into a shopping mall. So the first fact on which I rely in relation to Mr. Justice Rahim being right is this practice and his business as a property developer, Ramnarine's. But the second factual material piece of factual material that I say is relevant is that when Ramnarine wanted to make a gift of real estate, it was clear he made one. So we have one instance of him doing that and of Ravi thereafter being able to deal with that property on his own as he did.
But why was Ravi unable to deal, or him and his sister prior to the partition, unable to deal with this property? His power of attorney to his father didn't disable him from exercising the ordinary powers as the legal owner, did it?
No, it didn't.
Why is there a notional, well, he wasn't at liberty to deal with it concept lying around?
It'd be wrong to say that he wasn't legally entitled to deal with it. The evidence is that he didn't deal with it apart from the partition and the collection of certain rents from it. So those are the two pieces of evidence that show Ravi interacting with the property and collecting the rent from it. Although how much rent and from when till when is not entirely clear.
Is there any evidence he accounted to his father for the rent that he collected?
There's no evidence of that, no. The complaint between Ravi and Shakuntala and what prompted the partition is that Shakuntala was complaining that she was not receiving rent from the unpartitioned property.
As a 50% beneficial owner, she was presumably complaining.
Well, my lord, the difficulty...
Not as a trustee.
Well, the difficulty with that is that when we look at the evidence, we can see that, first of all, the transfer which gives rise to the presumption, is in 1976. Yeah. This all happens in 1992, and as a matter of authority, I would submit the court has to be careful to read anything into the dealings between Shakuntala and Ravi when trying to understand what Ramnarine intended in 1976. That's the antony.
I mean, they're all throughout a family that, whether always in love and charity with each other may not matter. They're close to each other throughout the relevant period, are they not? And the courts are not now, do they debar themselves from looking at subsequent behaviour as evidence of what the common intention was at the time of an acquisition?
No, that's correct. The courts have moved on from the idea that they cannot look at subsequent behaviour, but the court has to be careful about attaching weight to that subsequent behaviour, particularly when the question that behaviour goes to is the intention of Ramnarine, and at most what we can tell from Ravi and Shakuntala's dealings is what they might have thought they were entitled to. We don't know anything from that about what Ramnarine might have thought, in my respectful submission.
The evidence shows that father knew about the legal proceedings that led to the partition.
No, the evidence doesn't show that. I was going
to know about them.
I thought he knew.
So the finding by Mr. Justice Rahim, which seems to have translated into the Court of Appeal's decision, is, and I just need to be accurate about this, is that Ramnarine obviously was not a party to this action, and secondly, there is, I think, said in the Court of Appeal that there is no evidence that he knew anything about it. I'll have to take that reference, pick that reference up when I come.
The Court of Appeal said he did know about the dispute, but not the proceeding.
Yeah.
But putting it the other way around.
Page 591.
Pardon, I'm grateful. I'm sorry. Thank you.
Putting it the other way around, is there any evidence that the father, Ramnarine, actually treated this property as his own during the many, many, many years that followed the transfer?
There is no evidence of him, as that I have identified, of him doing anything apart from acquiring this land and, as it were, land banking it into the names of his children in 1976. And then it seems to have drifted along. One explanation for that may be that he was a large property developer with a lot of land holdings and simply land banked it. But that would simply be an inference that I'd be inviting you to make. There is no direct evidence of him doing anything other than acquiring, transferring, and then ultimately, in 2006, entering into this conveyance that he entered into, which is the second issue on dispute.
Do we know whether 37 to 39 High Street, whether he made a gift of it to Ravi before it was turned into a shopping mall or once it was turned into the shopping mall?
That I don't have an immediate answer to. I think the answer is that Ravi in 1964 was a medical student in Canada and then came back and also became a property developer. And I think I'm right in saying that it was he who did the development. I'd have to go to the note of evidence, but my understanding is that it was Ravi who built out the plot.
But can you help us? I tried to find it by looking at the transcript of the cross-examination of various witnesses, but there wasn't, or was there, very clear evidence as to why 3739 was, as you put it, obviously a gift. I mean, why was it obviously a gift? I mean, there wasn't, as I understand it, a deed of gift or a declaration of trust in favour of Ravi or anything of that kind. I mean, why is that property accepted by everybody to have been a gift, whereas the subject property isn't?
Well, my understanding is that was simply common ground of the trial, that was his property and it belonged to him and that it had been a perfected gift.
Yeah, but if you're going to set that against these circumstances we're investigating,
yes,
you need to know what the differences are, don't you?
Yes, my lord, but the disadvantage I have, obviously, is that all I can see is what is concluded by Mr. Justice Rahim on the basis of the evidence and what the parties put forward. And what he accepted in his judgment was that, in contrast to what had happened to the subject property, this had been a gift, and there was no dispute about that on the facts before him.
Yeah, all right. Thank you.
Do we know where the evidence is that father knew about the rent dispute? I'm looking at the bottom of page 590, top of page 591, where it says, but there is evidence that.
Well, the difficulty with that is not a finding that was made by Mr. Justice Rahim. And I haven't seen anything in the transcript myself that suggests that father knew about it. What Mr. Justice Rahim says in his judgment in relation to that is that father didn't know about it and that father was unaware of the proceedings. So that's as far as the evidence seems to go on that point, I'm afraid, my lord. That he was neither a party to the proceedings nor was there any reason to think he knew of them. So that is the factual landscape which we are stuck with and have to navigate. And in those circumstances, one has to then assess how the equitable presumptions worked, and one has to assess the criticism of Mr. Justice Rahim as how the evidential presumptions worked.
Help me on this. Did the evidence show that father was on good and close terms with either one or other of his children throughout?
It seems to have varied over time.
It's not always the same one, and not both. Yes.
In broad terms, he seems to have been on good terms with Ravi until there was a falling out, I think, sometime in the 2000s, at which point he moved in with Shakuntala.
And who was he living with at the time of the rent dispute?
I think at that point he was still living. He was not at that point living with Shakuntala, certainly. I think he might have been living on his own at that point. I'd have to check that.
You told us a little while earlier that the practice of the father was to deal with and trade properties that have been registered in the names of his children.
Yes.
Again, you don't have to do it now, but at some point, can you just be clear as to where the evidence is for that? Because again, it's not something which I could find very clear. It just seemed to be actually a dispute as to whether he'd ever used the power of attorney, other than in 2002, to transfer property that had previously been registered in one or other of the children's names.
Yes, well, if I could pick that up, my lord. The references I've got to it is that, first of all, there is a passage in the respondent's own witness statement at page 74 of the electronic bundle, which is paragraph 57, in which the respondent says that while Ravi was a student in Canada in 1964, he appointed Parr his attorney under the power of attorney. This power of attorney, Ravi told me, was done so as to allow Parr, who is a prominent and substantial land developer in San Fernando, to deal with any lands that he purchased or transferred in Ravi's name while Ravi was away.
Yes. That's
paragraph 57.
One imagines that's quite common when somebody's off island.
Yes. And it's a practice that was obviously the power of attorney was also then left unrevoked thereafter.
Yeah.
But yes, and the same is true of Shakuntala, and we then have.
What do you mean the same is true?
She was also subject to a power of attorney.
But was she off studying elsewhere as well?
She was. Yes, she was at one point.
By saying subject to a power of attorney, I think you mean she also gave a power of attorney.
She also gave a power of attorney. That seems to have been in line with his practice. And then we have the evidence recorded in the judgment of Mr. Justice Rahim at paragraphs 27, 50 and 51. So in the core bundle, that would be, first of all, the evidence that he records at paragraph 27, page 289, in which he indicates the power of attorney weighed heavily in the court's consideration. The obvious and overwhelming question remains that of the intention of a man whose business it is to purchase real estate, developing a practice whereby he uses his funds to purchase property, but permits the conveyance of those properties onto his children. Not only does he do so, but additionally he ensures that those children execute and register powers of attorney. So that is simply recording his practice. And then at paragraph 50 at page 297, It was the claimant's evidence, that's to say, this is the evidence of the respondent in this appeal, that Maharaj was in the habit of buying property in his children's names while retaining a power of attorney over them in order to have control over the property. And then finally, his reference at 71, which is page 302, that in fact in cross-examination, the first defendant, which is Shakuntala, testified that from the time they were young, Maharaj had powers of attorney for all three of his children, and he constantly bought and sold properties. The court accepts this evidence, and in these circumstances, a conveyance pursuant to said unrevoked power of attorney cannot, within reason, and does not incite suspicion. That's on the undue influence point, but that's where that comes up. There is also evidence from Shakuntala that she did not regard the land that was conveyed in 1976 as being vested in her beneficially, that it was a gift. She didn't think it was a gift, I should say. So
she seems to have changed her mind by the time she had her rent dispute.
Well, that was certainly before, but as far as it goes, insofar as this court is interested in expressions of interest from the transferees, that is the only other piece of evidence of the intentions of the transferees of the 1976 conveyance that I can put before the court.
Yeah.
I think the grandson said, didn't he, that he thought that he didn't think the power of attorney had been used possibly since the 1970s.
I think the 1980s. I think there is certainly in the cross-examination a dispute between the cross-examiner and that witness in relation to whether it had ever been exercised, his knowledge. So, my Lord, that's the factual picture that Mr. Justice Rahim was confronted with in relation to the first issue. And the way that he was invited to deal with that issue was by the application of, first of all, as I've said, the presumption of advancement, and in default of that, the counter-application of the presumption of resulting trust arising on a gratuitous transfer. In relation to the judgment of Mr. Justice Rahim, I should then take you to the judgment to show how he dealt with that point. And the first point to make is that he sets out the law as he sees it as submitted to him at page 287 of the electronic bundle. And that's between paragraphs 21 and 24. And the only point I wish to make about that is that no criticism is made on appeal of his setting out of the applicable legal principles in the Court of Appeal, and nor is any criticism made of his analysis of the law in that case. He then, having set out the presumption and counter-presumption, sets out the evidence that is available to him in determining how those presumptions should operate on the facts of this case. And those are between paragraphs 27, 28, and 29. In paragraph 27, Mr. Justice Rahim refers to the practice that I've just referred to of Ramnarine as a property developer, a large-scale property developer on this island, trading property and having the practice of vesting that into his children's names. At paragraph 28, he essentially says, further, I have evidence to show that when Ramnarine wished to make gifts, he did so. In other words, there are evidence of absolute gifts to Ravi in the form of the fees that funded Ravi's medical studies in Canada, and secondly, 37 to 39 High Street, San Fernando. And I've just been instructed that, yes, indeed, it was Ravi who developed the mall himself. Thirdly, Mr. Justice Rahim then deals with the counter-arguments that were placed before him in paragraph 29, said to go the other way. First of all, he rejects the suggestion that the power of attorney in 1964 is not material to understanding the effect of the transfer in 1976. Secondly, he deals with a point which is perhaps more at the forefront of the respondent's appeal before the board, that that Ramnarine describes himself as an agent on the face of the 1976 deed of conveyance. What he says about that is that that's a factor that has to be looked at, but that ultimately it doesn't help either way. And in my respectful submission, he was right about that. He was right about that because these presumptions operate and presuppose that there is something that is on the face of it a full transfer. What triggers these presumptions is the existence of a gratuitous transfer in the name of somebody else, which equity requires there to be an explanation for. The explanation is either a presumption of advancement or evidence that rebuts a resulting trust, and in the absence of that, the resulting trust presumption remains. And the reason why Mr. Justice Rahim was right not to attach any weight to the question of agency is that it tells us nothing at all about the locus of the beneficial interest, because all that is about is the mechanics of conveyancing, the mechanics of the acquisition. And the agency point is, of course, equally consistent with the fact that Ramnarine had to procure, in a non-pejorative sense, that the legal title became vested in Shakuntala and in Ravi. The third point that Mr. Justice Rahim considers and rejects is the point that is made that Ramnarine took the view that Ravi, who had undoubtedly become independently wealthy later in life, simply didn't need to have this property. There's no longer a reason for him to acquire it. That is, again, in my respectful submission, something that Mr. Justice Rahim was entitled to discount on the basis, as he explains, that that's equally consistent with the fact that Ravi ought not to, in due course, inherit any such property that he was already well provided for.
Where are you referring to now in the judgment?
It's C, 29C.
Yeah.
Now, what's that? That's a finding of the court. But what's the consequence?
These are the arguments that were put before Mr. Justice Rahim, suggesting that Ravi might be the beneficial owner of the property after all. And C, the point that was made in C was that it was suggested that because Ramnarine had taken the view that Ravi was independently wealthy and didn't need this property, that the respondents were saying, well, that indicates that it was his property and it was taken away from him because of his acquisition of wealth. So inconsistent with my case. But what Mr. Justice Rahim found was that it was actually ambiguous, and it was equally consistent with the idea that there was no need to supply Ravi with any further real estate because he had already become independently wealthy. So it was a factual proposition against me that was put before the trial judge, my lord.
Well, what does the judge mean by his reasoning that it was only meant to assist him by way of possession of an asset in his name until he was financially independent? If he wasn't the beneficial owner, what could the judge have had in mind there?
Yeah.
Well, my lord, one thing he could have had in mind was that, as has been pointed out, that there was an entitlement on the part of Ravi to collect rent, and that seemed to have been an informal arrangement, the basis of which we don't have any evidence about.
But if there was an entitlement to collect rent, why doesn't that make Ravi the beneficial, well, and his sister prior to the partition, the beneficial owners? I mean,
well, it needn't, because of course that could simply be something that was allowed to happen to supply money to the children in the interim. That doesn't necessarily mean that that included a full transfer of a beneficial interest.
Well, it might not. But if the only facts you know are A, a transfer absolutely apparently into the names of two children, and B, that from the date of the transfer until they fall out with each other and partition the property, they're collecting the rent. If that's all you know, it doesn't lead to some kind of, well, there's a very strange kind of right to collect the rent without a beneficial interest. You just think it means they've got the beneficial interest.
Well, it could, on those facts, it could simply be an act of parental largesse for that purpose and that purpose only. But those are not the only facts, of course.
No, sure.
Might just ask this too. If the purpose was meant to assist him by way of possession of an asset in his name until he was financially independent, as I understand it, he returned after completing his medical studies, and for very many years after that was gathering the rents and furthering his own interests as a property developer.
Yes.
And so there's no evidence it was only intended to assist him by way of possession of an asset until he was financially independent, is there?
The only evidence that we have is the practice to which I've referred to that Ramnarine was engaged in relation to vesting properties in his children. And that was, as I say, a very common practice that he adopted. And in my respectful submission, Mr. Justice Rahim was firmly entitled to attach weight to that practice.
But what does one mean by that? He might be vesting it in them beneficially. The evidence seems to show that father vested properties in the children, but thereafter sometimes directed dealings with the property, either by using a children's power of attorney, presumably, or telling the children to transfer them to somebody else.
Yes.
But which is evidence of some degree of control. But why is it evidence of there being no beneficial ownership in the children?
Because the indication or the factual findings that Mr. Justice Rahim made and the evidence of the respondent that I referred you to shows that when he wanted to buy and sell them and replace them with other property, that's what he did. In other words, he didn't account to his children. There's no evidence he accounted to his children for any surplus purchase monies, for example, or that he involved them in any other way in the acquisition or sale of the property. The evidence that we have suggests that Ramnarine regarded himself as absolutely entitled to buy, sell, trade the property that was vested in his children. And in my respectful submission again, Mr. Justice Rahim was entitled to have regard to that as simply, as it were, a landholding structure of some kind that he adopted, a practice that he adopted. So, my Lord, that's what I say about the about counter-argument C. It is a point, but Mr. Justice Rahim was entitled, in my respectful submission, to form the view that it was a point that cut both ways and therefore didn't much illuminate the issue either.
But these are, I mean, the process that we're looking at here in the judgment is simply the judge drawing inferences from various pieces of evidence. I mean, the actual fact is that the father did nothing about this property, as you've quite properly conceded, from the moment he acquired it and put it into his children's name until he transferred it in 2002. I mean, that period of doing nothing, obviously a lot else happened. I mean, collecting rents, partitioning the title and all the rest of it. But I mean, all that the judge is doing here is drawing inferences from various issues or arguments that have been raised. I mean, this isn't quite the sort of area of fact-finding that one conventionally says the Court of Appeal should never interfere with, because he's seen the witnesses and all that sort of thing.
Yes, my Lord, except that, of course, Henderson says two things. One, the Court of Appeal shouldn't intrude into the primary fact-finding exercise. But secondly, an appeal court should be quite reluctant to look at how the evidence is balanced unless the judge has gone plainly wrong.
You've got to respect the tribunal, of course, we accept that, but anyway.
So my Lord, those are the only facts that are in evidence in relation to the dealings. And I should say, of course, that again, in my respectful submission, the board should be careful to draw conclusions from inactivity on the basis, of course, that property developers land bank. We know that happens until something is ripe for development.
Was he a property developer or was he trading in properties or both?
He seems to have done both, my lady. So those were the facts that were available to Mr. Justice Rahim, and that is the balancing exercise that he undertook.
So why is the power of attorney not neutral in the same way?
Well, the power of attorney is not neutral in the same way because of how he used it, not because of what it says. The evidence that we have is that insofar as powers of attorney were used by Ramnarine, they were used by him, again, I have to, in a sense, pray and aid the respondent's evidence. They were used by Ramnarine as part of his business practice as a property developer when he needed to buy, sell and trade.
Yeah, but the point I'm making is that the Court of Appeal wasn't impressed by that because they accepted that the power of attorney would be exercisable even if the property was one that did beneficially belong to the son. Yes. So therefore you can't draw an inference from the fact you've got this power of attorney or indeed that on occasions you've exercised it, that the property in respect to which you exercise it belongs to you rather than to one of your children.
I'd have to agree with that. The power of attorney doesn't tell you anything about the underlying beneficial ownership.
And it covered the mal, didn't it?
I'm sorry, Madam.
It covered the mal.
It covered the mal on its terms, that's correct. It wasn't exercised, obviously, in relation to the mal. And I think the only point I can make in response to your Lordship's observation is that we have evidence or the evidence shows that when Ramnarine dealt with properties subject to his power of attorney, there is no suggestion ever that he felt he had to or did account to any of his children in relation to any of the funds realised by any of them. So the relevance of the power of attorney is not so much what it itself says, but first of all, what it tells us about Ramnarine's business practices, and secondly, how it has been exercised historically as far as we are aware from the evidence, which suggests that Ramnarine did not, when he sold a property which was ripe for sale or developed a property and sold it, then turn around and account to the relevant child with the purchase money.
You say there was this practice, but there's no specific example of this happening and there being no account.
The only two pieces of evidence that I've come across are, first of all, the exchange in cross-examination about the exercise in the 1980s, which is not a very detailed account. And secondly, the fact that this seems to have been evidential common ground in the sense that the respondent, the passage in her witness statement that I've taken your lordships and your ladyship to, accepts that that was
very generalised evidence.
It is.
Yeah.
But nonetheless, it's not controversial evidence. That's, I suppose, what I'm driven to.
But I mean, you've got, for your thesis to work, you've got to assume that every property that the father bought and put in the children's name at his own expense continued to belong to him.
My lord, no, because one has the contrast between 37 and 39 High Street and the subject lands.
I know we do, but
what is the contrast?
Well,
37 to 39 High Street, the son exercised the rights of an owner by developing it and collecting the no doubt very greatly increased rents attributable to having spent his money on developing it. In relation to this property, the son didn't develop it and simply collected the rents attributable to what might otherwise assume to be his beneficial ownership without developing it. What's the difference? The
only difference is that it is common ground on the evidence that 3739 was and was intended to be a gift.
Well, quite.
As Mr. Justice Rahim found.
But if you're looking at the parties' conduct, particularly the children's conduct, what's the difference between developing a property and simply collecting the rents of the undeveloped property?
Well, my lord, I see that, but then the question obviously is what was the donative intent, if any, at the time of the transfer? And there being no factual controversy about 37 to 39, that there was explicitly meant to be a donative transfer by father, and that was never called into question and was assumed to be factually right. It is appropriate, or was appropriate in my submission, for Mr. Justice Rahim to note that contrast.
I suppose the nub of my question is, if the party's conduct in relation to a property which it's agreed was the son's property beneficially, is in terms of the collector and making use of the rents and profits of the property, the same as the evident conduct in relation to the subject property, why does that history point in any way to the subject property not being beneficially owned in the same way?
I see that point, my lord, but the only difference that I can point to is that it was accepted that with 37 and 39 that was definitively a gift.
Yeah.
So everybody in the family knew from whatever source that 37 to 39 was a gift.
Was his to have, yes.
Was his to have.
Yeah.
And we don't know on what they based that. It may have been based on conversations, but
It was just never controversial.
But it was not controversial, and so we didn't need to go into why it was that everybody believed that about that land. Yes. But they didn't believe the same about this land, or at least now they say they didn't believe this.
Well, on this piece of land, it's clear that at least in 2006, Ramnarine didn't think that, because he conveyed it beneficially and with a view to donating
We'll get to that, what it was that he conveyed, yes.
So, my lord, my lady, that's where Mr. Justice Rahim's analysis of the facts goes. Those the factual material he had available to him, and in resolving the difference between the parties, he, as he was invited to do by the parties, applied the various presumptions that apply, and he took the view, correctly in my submission, that the presumption of advancement was the first, but is also the weakest, the most gossamer thin of those two.
Is it gossamer thin between parents and children? I accept that there's some inroads have been made into it between spouses, for example, cohabitee. Well, I'm not even sure there is one for cohabitees, but
no, there isn't.
I think everybody takes a more modern view of matters. But do the cases show it's worn gossamer thin between parents and children?
They do in this context, where the child in question is a grown-up rather than an infant. The underlying policy behind the presumption of advancement that one would provide for an infant child doesn't apply with anything remotely resembling.
Advancements aren't just made to infants. Advancements in the ordinary technical sense are transferring capital by way of advancement.
Minors in that case.
School fees for infants.
No, but the way that the cases have developed in this jurisdiction is that they have, or rather in the UK courts, has been to note that the presumption has been around too long to be abolished by the courts, but that it should not be given any particular force in the context of parent-child advancements, specifically where the child in question is of an age of majority or older. So in this case, Ravi, at the date of the 1976 transfer, was 34 years old.
Grown up. Yeah.
Grown up. And now I can make that point good. I think the most convenient place, if your lordship doesn't mind, is for me to take you to my case rather than to the unwieldy bundle of authorities. What I've done there is to set out passages from the more recent cases on the presumption of advancement, which address the point that your lordship raises. It's bundle 648, and it's paragraph 11 and following of my learned friend's case. There are three main passages. Paragraph 13 is Lord Reed in Pettit, which is about the husband-wife presumption, where the point is being made that economic circumstances have changed. Then Lord Hodson at paragraph 14 of the case indicates that the presumption of advancement, again in favour of a wife, has rather dropped away. And then Lord Justice Neuberger, as he then was in Lashkar and Lasker, at paragraph 17, sets out the position that the presumption of advancement still exists, although it was said long ago as 1970 to be a relatively weak presumption, which can be rebutted on comparatively slight evidence. See Lord Upjohn. I would add that it is even weaker where, as here, the child was over 18 years old and managed her own affairs at the time of the transaction. So my lord, this is material because, of course, when considering the presumption of advancement in a parent grown-up child situation, the law should apply that presumption very slightly. It has worn extremely thin in that context, as Lord Justice Neuberger indicates. And in my respectful submission, Mr. Justice Rahim was right, having regard to the nature of the business undertaken by Ramnarine, having regard to the evidence of his business practices, having regard to the fact that Ravi had pursued a medical career rather than a property development career before then becoming a successful property developer in his own right, that all of those facts are sufficient to displace the light presumption of the presumption of advancement between a parent and a grown-up independent child.
Can you just remind me, in 1976, at what stage was Ravi in his studies or work life?
I'd have to look that up. I believe he was back on Ireland having completed his medical studies, I think, but I'd have to check and come back to you if I may, my lady. So having applied that presumption and having engaged in the sort of standard battle of equitable presumptions, what Mr. Justice Rahim says is, well, the presumption of advancement, I say, is rebutted, in my submission correctly on the basis that it is a very slight presumption. And as the case was presented to him, the only other position that was placed before him was that then the resulting trust presumption arising on a gratuitous transfer, which the 1976 conveyance was, is the last presumption standing. And in my submission, he was right to do that on the basis that the only evidence that he had before him was that which I've indicated to the board, which is either neutral on the question of beneficial ownership or goes with the grain of the presumption of resulting trust on the basis that it is consistent with his practice as a property developer.
He didn't get to his conclusion that there was a resulting trust favour the father by that sort of rather mechanistic approach, did he? I mean, my reading, and I think this was also the Court of Appeal's reading of his judgment, was that he might well have found that the property belonged to the son, but for the power of attorney. I mean, if you read paragraph 26 of the judgment, taking all the points that were being debated at the trial into account, he was still thought that there was a strong case for saying that it was intended to be a gift, and might well have found that, but for what he says was the effect of the power of attorney, which is paragraph 27.
Yes, my lord, and certainly the way the Court of Appeal read the judgment was that that was really the sole issue that Mr. Justice Rahim, that led to Mr. Justice Rahim's decision. But as I hopefully have indicated earlier on, he does go on in paragraphs 27 and 28 to list other pieces of evidence.
He knocks down one or two other skittles afterwards, but I mean, he says what he says, but it does look, on a reasonable reading of his judgment, as if the power of attorney was pretty central to his reasoning on this issue.
Yeah, yes, but if your lordship is right in that on a proper analysis, this power of attorney is neutral and doesn't really tell us anything either way, then it falls away for the purposes of that. And the
why aren't you left with the position that, on a fair looking at all the facts, including those that my lords have mentioned about accepting rents and everything, things are more consistent with it being intended to be a gift, which would be in fact consistent with the title of the property?
Well, my lord, two things on that. One, I would suggest it would be wrong to draw any conclusions from the title of the property, because the presumption arises precisely because the title of the property has been vested in a donee. Secondly, the second tier of the question really is to have regard again to the Henderson situation, which is to ask oneself not whether one might have reached a different conclusion, but whether Mr. Justice Rahim's assessment of the facts and his factual assessment of whether the presumption was rebutted was plainly wrong. And in my submission, one cannot go that far in this situation, where Mr. Justice Rahim also prays in aid the other facts in paragraphs 27 and 28 of his judgment, some of which were uncontroversial. Those would be the two things I can say in response to
whether it's plainly wrong is rather dependent on what view the appellate court takes of it.
My Lord, yes. But if the objection to Mr. Justice Rahim's conclusion on this point is that in relation to on this hypothesis, an ambiguous power of attorney, that he ought not to have placed any weight upon it, then the conclusion the conclusion derived from that is that the power of attorney falls away as a useful piece of evidence. And then the next question is what evidence remains that was taken into account.
But then, if the judge below has placed what he himself calls overwhelming weight on the power of attorney, and the court, the appellate court takes the view that just isn't a rational way of looking at the power of attorney, and it cannot be given that much weight, so that it falls out of the calculation. One doesn't know what the judge would have made of the other pieces of evidence which are mentioned. One has to go, if one's in the appellate court, and go and do the job again, doesn't one, with such primary findings of primary fact as the judge found, and then make one's own assessment of what the inferences are to be drawn.
Well, my Lord, on that hypothesis, yes, except that the power of attorney, as I say, retains some importance and is appropriately considered by Mr. Justice Rahim as a window on Ramnarine's dealings and his business and what he did. So in that sense, I don't accept it does fall away and doesn't have that consequence. Yeah. Now, I should then quickly turn to how the Court of Appeal dealt with this issue, and that is to be found in the judgment of the Court of Appeal at paragraphs 46 and following, which is at page 583 of the electronic bundle. So at paragraph 46, the Court of Appeal makes the, in my submission, correct point that there isn't really a meaty dispute of law in relation to any of this. The relevant law on this issue is simply stated, and then they set out the presumption and counter-presumption I've described. The Court of Appeal then proceeds at paragraph 47 to set out the underlying facts which trigger the presumption of advancement, or, if rebutted, the presumption of resulting trust. They correctly point out that presumption is rebuttable, but they do then fall into error in paragraph 47 on the basis that they then suggest that this is the fifth line from the bottom at the end. The question then becomes, if the presumption of advancement is rebutted, was it Ramnarine's intention for the disputed lands to be held on trust for him? That is, if what is being applied here is a presumption and a counter-presumption, not really the right question, because one is then not on a quest for an actual psychological intention if one is simply dealing with it as a battle of presumptions, but one is simply asking whether that intention is supplied by an irrebuttable presumption of resulting trust, or an unrebutted presumption of resulting trust. And the Court of Appeal then at paragraph 50 go on to correctly note that the finding by Mr. Justice Rahim was a finding of fact, a factual matter. Yeah. And they then proceed, having adverted to what I say is the right test, which they then didn't apply, they then proceed to essentially simply re-evaluate the various matters that were placed before Mr. Justice Rahim without, in my submission, really engaging with the question as to whether Mr. Justice Rahim had reached a conclusion which was available to him within the spectrum of what is reasonable as a finding of fact on the part of a trial judge. And in so doing, what they focus on is really only his analysis of the power of attorney without having regard to what I'd call the broader picture of paragraphs 27 to 29 of Mr. Justice Rahim's judgment, which I've referred to. They conclude at paragraph 57 that the power of attorney is neutral. The Court of Appeal does refer to 37 to 39 High Street, San Fernando, and the recording of Mr. Justice Rahim there, that it is clear from the cross-examination of the appellant that Mr. Maharaj had provided at least one other property as an absolute gift to Ravi, at which Ravi and the claimant constructed a mall. In addition, Mr. Maharaj also funded Ravi's medical studies. So they advert to the fact that there is evidence heard in cross-examination that there was an absolute gift. But they then simply conclude that the relevant issue, that is to say at 61, the issue of the status of the power of attorney wasn't properly analysed, and they go in a different direction and say that the presumption of advancement was not rebutted. And in so doing, in my respectful submission, the Court of Appeal fell into the classic trap that Henderson warned them against, which is that they selected only some of the facts that Mr. Justice Rahim had available to him, and did not look at the broader picture in relation to Mr. Ramnarine's practices, and fastened also on facts selectively which were not accurate. So one of the conclusions that's drawn by the Court of Appeal at paragraph 67 through to 69 is that some assistance could be derived from the fact that when, this is jumping ahead to 2006, Ramnarine went to see his retained lawyer, Dr. C. Prasad, for the purposes of entering into the 2006 deed of conveyance, that at paragraph 69 it is recorded by the Court of Appeal that Dr. C. Prasad considered the property to belong to Ravi, as one would expect. Dr. C. Prasad told Mr. Maharaj that he was transferring property that did not belong to him, and he had to pay the money over to Ravi. Now, the reason why that is again, an example of the sort of trap that Henderson is cautioning against is that, in fact, that isn't an accurate picture of the evidence. If one turns to the judgment of Mr. Justice Rahim at page 303 of the bundle, it's quite clear that there was other evidence in relation to that 2006 meeting. And what Mr. Justice Rahim records is the evidence which appears also on the face of the cross-examination record.
So sorry, could you give me the page number?
I'm so sorry, it's page 303.
Thank you.
And it's at the bottom of paragraph 72, which is the cut-off paragraph at the top. In it, he says the court has no reason to doubt Mr. C. Prasad when he testified about the apparent knowledge and understanding of the transaction. That goes to undue influence. According to Dr. C. Prasad, Maharaj also had plans for the money he was to collect, which was for the purpose of charitable donations. So the idea was not on the evidence that Ramnarine thought he had to account for that money to Ravi. Ramnarine's intention, and on the basis of which the witnesses were cross-examined, as the record shows, was that Ramnarine was intending to take the $550,000 realised by the sale of the property and make a charitable donation, that being a finding of Mr. Justice Rahim. That finding does not find its way into the Court of Appeal's judgment, because the Court of Appeal hasn't undertaken, I submit, a proper analysis of all of the available factual material, and the reason why it hasn't done that is...
I'm so sorry to interrupt. Do we have the underlying transcripts of the cross-examination?
Yes. You will find the passages at 425.
Yeah.
And that is the... So 425 is important, really, for two reasons. One, it contains the reference to the charitable, the cross-examination on the basis that the money was intended to be given to charity. So that is the cross-examination of Kieran.
That's the cross-examining Kieran.
Yeah.
I was hoping to see what Mr. C. Prasad said.
835. I'm sorry, just a moment. What I'll have to do is find it
You're
on...
saying that the Court of Appeal misdescribed Mr. C. Prasad's evidence?
Well, it omitted that part of the evidence altogether, which is referred to in Mr. Justice Rahim's judgment as something that Mr. C. Prasad said in relation to the object of what it was that Ravi wanted to do.
Absolutely, but at the moment we've seen what is being put to Kieran.
Yes. I'll have to dig out the C. Prasad reference, my lord, but it does feature as the basis on which Mr. Coilas cross-examines Kieran in the main, that was what he was being told. That in your witness statement you speak of your grandfather's business ability and that he was a successful businessman. Did you hear Dr. Siprasad say that his money that was being received with respect to this purchase was intended to be given to charity? Answer, yes.
That's the bit I'd like to see.
Yeah, sorry, that's again, unfortunately, the cross-examination of Kieran.
Yes.
Can you leave me to find that, my
Yes,
lord?
of course.
Because it's not obviously
I'm conscious of the time, so
on my
by all
note.
means supply it afterwards.
Yes, I'm sorry.
The passage the Court of Appeal rely upon, they set out in their judgment, paragraph 43, and that it's correct what they say about that passage.
Paragraph 43, my lord, just a moment. This is 43 of the Court of Appeals judgment.
Yeah. Look at 580.
Oh, yeah, yes, that is correct. So that is the evidence on which the Court of Appeal rely. But as you see, Mr. Justice Rahim's passage, which I'll have to take you supply the reference to later on. But that is what I say is where the Court of Appeal go wrong, which is that first of all, not identifying a plainly wrong ground, they then re-evaluate the evidence and don't attach weight to all of the evidence.
Well, the two merge into, because if you read a bit further on page 580, with the cross-examination of the lawyer, I mean, he does there mention that $500,000 being used to give as donations,
yeah.
but it then becomes a conversation as to whether the father thought he ought to tell his son that that's what he wanted to do.
Yes, my lord, but as I say, then Kieran is cross-examined on that, and Kieran, in cross-examination, gives his evidence that he was aware that that was his grandfather's intention. So that is the totality of the evidence.
It may have been his intention, but
well,
where do you say Kieran says he was aware at the time? That he says he wasn't aware at the time.
He wasn't aware at the time, but I was not aware at the time. He says, yes, I was not aware at the time.
Well, he's answering, did you hear Dr. Siprasad say that this money? And he says, yes, he did hear Dr. Siprasad say that, but he wasn't aware of it at the time.
Yes, well, that is the totality of the evidence on that. But my lord, again, it's relevant. If the question is what can we infer from intention, well, if his intention was to give to charity, that is one piece of evidence that we can take.
But I mean, he also, the evidence from Dr. Siprasad was that the father said that he accepted that he would have to account to the son for the money.
Yes, he does say that at one point.
What did happen to the money?
My lord, I don't know. We don't know.
It's sitting in a large sack on the floor of Dr. Siprasad's office.
No, I don't think so. But what certainly never happened was that the money was paid to Ravi. That is understood. So Ravi never received the $550,000 dollars. So where else the money went, I don't know. But what did not happen was that Ramnarine acted on the basis of that passage of cross-examination and thought that the money should go to Ravi.
Ravi was murdered 4 days later, so
4 days
I understand that it wouldn't have reached him.
Or his estate.
Right.
So, my lords and my lady, what I say about that issue, therefore, is as briefly as possible, is that the basis on which the battle lines were drawn were on these presumptions and counter-presumptions. The presumption of advancement is a very light presumption, was, I submit, correctly found to have been rebutted by the trial judge on the basis of the evidence that he heard, leaving the presumption of resulting trust as the last presumption standing, and there was factual material available to Mr. Justice Rahim, which would allow him to conclude not just that that presumption was not rebutted, but that reinforced the presumption in light of his findings as to the business practices of Ramnarine and on the basis of the accepted evidence that when Ramnarine made gifts of real estate, he intended to do so, and it was clear. That's 37 to 39. So that's my essential point in relation to the first of the two transfers. In relation to the second of the two transfers, The issue that arose at trial was whether the second transfer in 2006 had been procured by undue influence.
No, this is on the assumption that you're wrong on the first point.
Well, my Lord, if I'm right on the first point, then that changes the landscape in which the board should assess the presumption of the undue influence point, because of course if what Ramnarine was doing was selling something that was beneficially his and simply transferring a bare legal title, that puts an entirely different complexion on the questionability of the transaction.
Well, the claimant could only challenge that if she was a beneficiary under his will.
Yes, exactly. It totally changes the complexion of how one deals with undue influence.
In fact, both the beneficiaries under his will were before the court, weren't they?
Yes.
Yes. Unless he was an insolvent estate or anything like that, which seems highly unlikely.
No.
Yes, if you lose on the first issue, I've been struggling to understand what undue influence has, in a sense, got to do with it. If Ravi was the beneficial owner of the property, then a purported sale of it for what appears on such evidence as there was to be 1/10 of its market value by somebody purporting to act under a power of attorney would be, I think, obviously a breach of fiduciary duty, of which in this particular case the recipients would have notice, wouldn't they?
Well, my Lord, I have to confess, one of the points that's caused me...
I'm glad I'm not the only one.
No, one of the points that causes difficulty in analysing this appeal is the course that was taken at trial, and that's not intended to be a criticism of anyone, but it leaves one in front of your lordships and your ladyship with a case that has taken on a particular shape already. And the shape that this case has taken already is that when the proceedings were first issued, as you will see from the statements of case, there are allegations of fraud, conspiracy, breach of fiduciary duty, and the sorts of matters your lordship has referred to. Those were all dropped at trial. So one of the issues that I hadn't fathomed when I was first instructed in this matter, for example, was the ground of appeal of joinder of the estate and non-joinder, which seemed to me to be a point of complete technicality. But the relevance of joining the estate seems to have fallen away anyway, because one possible, I'm not saying it would have succeeded, but one possible analysis was that Ramnarine acted of his own free will, and then the question comes, well, what is the cause of action against his estate for the sorts of matters your lordship has referred to? The difficulty with that, and of course it's not really for me to express a view on that, but the difficulty with that in front of your lordships is that those issues were all in play on the pleadings, and they certainly were in play shortly before the trial. But if your lordship looks at the judgment of Mr. Justice Rahim, paragraph 9, you'll see, this is page 284, your lordships and your ladyship will see what fell away by the time of the trial and what was no longer an issue. And what Mr. Justice Rahim records is that notwithstanding the pleaded case, the claimant accepted that it was not put to Dr. C. Prasad that the deed was not signed by Maharaj, nor was it put that it was signed at a later date, since it became clear that such a claim could not be properly furthered. Additionally, the claimant admitted that proof of Ravi's mental decline was equally impracticable and was no longer part of the claimant's case. So a lot of evidence surrounded whether Ramnarine was I think that should be a reference to Ramnarine, certainly not Ravi. A lot of the evidence was around whether Ramnarine had become vulnerable and unable to make decisions. That fell away by trial too. And finally, the claimant also appears to have abandoned her case of fraud, as the only issue identified in her submissions was the issue of undue influence. Additionally, the claimant made no submissions on the issues of conspiracy to cheat and fiduciary duty, and that can only have been a claim in relation to Ramnarine. It thus appears...
I mean, you're right. There is a pleaded claim that the transfer on these terms was a breach of fiduciary duty.
Yes.
So that wasn't pursued.
No.
And yet there did survive what the judge describes as issue 2,
yes,
which was whether or not this was an invalid exercise of the power, but that seems to have been simply an issue of construction of the
That's correct, my lord.
power, rather than, for example, whether it was a fraud on the power.
That's correct, and that wasn't pursued on appeal in the Court of Appeal. That fell away. So one is left in a situation where a number of points that might excite the interest of the board, understandably, as being issues that need to be investigated, simply procedurally did not feed through into the trial and thereafter into the appeal, and they're therefore not issues before the board. So by the time one gets to trial and then to the Court of Appeal, the position as between the parties is that Ramnarine is not suffering from a mental decline. The medical evidence that was called at trial was about his physical state and not about his mental state. There was no evidence that he was vulnerable mentally at the time he entered into the transaction in 2006, and nor was it suggested that he had done anything improper with his attorney's hat on, if I can put it that way, in 2006 either. So the position one then reaches at trial is that Ramnarine was mentally competent to do what he did, and that Ramnarine personally had done nothing wrong as an attorney in doing what he did. What remains is the suggestion that Ramnarine did what he did because his entirely free will was overborne by pressure applied by Shakuntala D1 and Kiran D2. That was the issue that remained. And so
may I be clear, you're proceeding now on the assumption against yourself that the beneficial ownership did pass?
Yes.
That the property was sold at an undervalue for the moment, and that the money didn't reach the estate?
My lord, there is no evidence I've seen that the money reached the estate, so one has to assume that. And on undervalue, I have some points.
Well, how could that not be an improper exercise of the power?
My lord, I don't have access to the Fifth Amendment in this jurisdiction. However, all I can say to your lordship is that I am tied by what I have in my electronic bundle.
And the only point taken on the validity, the exercise of the power of attorney, if one looks at 31 to 34, is that it was said to have passed its shelf life, and the judge said, well,
correct.
No, it hadn't.
Correct, and it hadn't. It was irrevocable. Well, yes. It hadn't been revoked.
But it hadn't been revoked.
Correct, yes.
Yes.
So one is left in slight Alice in Wonderland territory here, because we're left with the rump of a case that has the perplexing features that your lordship has pointed out, and as you can possibly appreciate, requires a degree of tiptoeing by appellants counsel in relation to issues that are simply not open on the appeal.
Yes.
And are not open on the appeal not because of some procedural tricksiness, but are not open because a conscious decision, for whatever reason, has been taken much earlier on in these proceedings, that the one person who shouldn't be joined is Ramnarine or his estate, yes. And that the one thing that shouldn't be maintained is a cause of action in relation to Ramnarine's acts in 2006. Or
perhaps an allegation of personal wrong done.
Personal wrong, yes.
Out of respect to him as the father of the family.
Yes.
Yes.
So we are left in this this position, so that the only allegation that is made is not aimed at Ramnarine, but is aimed at Shakuntala and at Kiran in the first instance, D1 and D2, that they unduly influenced Ramnarine in 2006.
But were we to come to the conclusion that we are bound to approach the matter on the limited basis upon which you're submitting we should, but we were nevertheless to come to the conclusion that Mr. Ramnarine, acting as he felt entirely properly, was nevertheless induced, persuaded, or led to act as he did because of the circumstances in which he found himself and the pressures that were exerted upon him. Would it be your submission that we are still, in those circumstances, unable to find that the Court of Appeal approached the matter correctly?
My Lord, I would say you are unable to find that in those circumstances. Once one sets out the parameters of the dispute that was left to be determined by the Court of Appeal. Could I address you on that in a more substantive way, just taking your lordships with an eye on the clock quickly through the submissions on undue influence? The undue influence allegation is slight shifting sands in this case, because it starts off as presumed undue influence as far as I can see. There is a suggestion of a child-parent relationship giving rise to a presumption. By the time of trial, Mr. Justice Rahim considers the rival contentions and takes the view that actually this is about some form of actual undue influence, that the relationship must be shown to have been one in which trust and confidence was reposed by Ramnarine into one of, or if not all, but at least one of the appellants. I think I'm right in saying that before the board it is now being suggested that we are in the territory of back to presumed undue influence, possibly because of Kieran's power of attorney. So there are different strands of undue influence which I think have emerged over the course of
the Ettridge kind, rather than the categories of an irrebuttable presumption, as you get, for example, from between parents over a child. Because those presumptions, as I think Lord Nichols explains, can't really be rebutted if the transaction is clearly disadvantageous.
My Lord, yes, but one has to, again, I think, look at the totality of...
But we're not in that territory. We're where you have to infer or presume a relationship of dependency from the fact that there is a relationship of trust and confidence, and secondly, in the nature of the transaction.
Yes. So the way in which, I think it's probably instructive to just set out the way in which the matter was approached as a matter of evidence before Mr. Justice Rahim. Essentially, what was being suggested to Shakuntala and subsequently to Kieran in cross-examination was that they had attained an ascendancy over Ramnarine and had effectively fallen into the overborne will category, and that seems to have been based in part on the point that was recorded to have been abandoned by the trial judge, which was the general mental decline and mental frailty of Ramnarine. I have looked carefully through the transcript to see the extent to which Kieran's power of attorney was put in play in evidence, and I think I'm right in saying I've only found one reference to it in passing in the transcript, which is at page 425, a part of the way, halfway down the page, where Kieran is asked, were you not his power of attorney? And Kieran says yes. But that is about whether or not Kieran knew what it was that Ramnarine was planning to do with the property.
Well, presumably that was in the bundle.
Yes, it was in the bundle.
Yeah.
Yes, it was indeed. Absolutely. So that's how the evidence proceeded. It was essentially on the basis that it was said that Shakuntala and Kieran had dominated Ramnarine, and that is what led to the 2006 transfer. And one can see that because the cross-examination of both Shakuntala and Kieran ends with, I put to you that type questions which set out the case that is being put to them, which is very much about their dominance. So Mr. Justice Rahim was not dealing with an allegation that there was some presumed undue influence to be inferred from Kieran's power of attorney. He was being presented with a case that Shakuntala and Kieran had lent to an unacceptable degree on Ramnarine in 2006. Now, the problem with that version of the case is obviously, first of all, the matters that were abandoned in paragraph 9, including the mental frailty issue, which is the fulcrum of that allegation that he was vulnerable and was exploited. But as Mr. Justice Rahim notes at paragraph 9, that was no longer the contention that he was in any mentally vulnerable state. And Mr. Justice Rahim then sets out his findings in relation to undue influence and the behaviours of Shakuntala and of Kieran at paragraph 62 of his judgment and following, which is page 299. He very much proceeds on the basis that this is an allegation of some actual dominance or actual influence, and says the court is of the opinion the claimant has failed to prove there existed a relationship. He finds that the evidence suggests that he was not beholden to either Shakuntala or Kieran in relation to his financial affairs, that he didn't repose trust and confidence in them generally in relation to his business dealings.
Well, the first sentence of that paragraph is a conventional, is there a relationship of influence type of question, rather than of dominance. I mean, there can be a perfectly healthy relationship of trust and confidence without domination going on.
Yes.
But it's nonetheless sufficient to lead one to stage 3 and ask whether the transaction cries out for an explanation.
Yes, except that he, of course, is proceeding on the basis of the evidence that he has heard.
Yes.
So he says at 61 there is no presumption of the relationship, so it's not presumed. And he then says the court is of the opinion the claimant has failed to prove the second thing, that there existed a relationship under which Maharaj generally reposed trust and confidence.
Yes.
There's no reliable evidence from the claimant that at the time of the conveyance Maharaj was bound or beholden to his daughter for his general care or support. In fact, Dr. Ramnaroop in his cross-examination testified Maharaj would only have needed assistance in some of his day-to-day activities. And he then notes that there was a subsequent deterioration in Ramnarine's health. And he concludes at 63 that this court, in this court's view, applied equally to Maharaj's ability to look after his own financial affairs. The evidence on the part of the claimant has failed to prove that Maharaj reposed trust and confidence in any of the defendants in relation to the management of his financial affairs.
Now he had, if I can just pause you there for a moment. I mean, he had, as you've just pointed out to us, he had heard the evidence of Kieran, the grandson, about being given a power of attorney by his grandfather, and I think using it. No?
Never used, no. There's no evidence that Kieran used.
But does he not, in the evidence that he gave, say that he did for the benefit of his grandfather run the I mean, I'm paraphrasing now, run the properties, manage the properties?
I think he goes so far as to say he helped, but that he basically looked up to his grandfather as being the person who dealt with his business interests, my lord. I think that's as far as it goes. The only reference I have found, as I say, to the power of attorney that Kieran had is the reference in passing at 425. And the power of attorney didn't really assume any prominence at all in the evidence. And Kieran really didn't assume that much prominence in the evidence either.
It may not have, but it's a piece of evidence.
It is.
In any event, isn't it?
It's a piece of evidence in any event, yes. But
I mean, it's prima facie unlikely that you'll give a power of attorney in those wide-ranging terms to someone in whom you don't repose trust and confidence.
My lord, I see the point, and yes.
I wouldn't, but I shouldn't rely on what I would or wouldn't do.
But my lord, that then has to be put into the mix of what was found as a fact by Mr. Justice Rahim.
Yes.
And what was found as a fact by Mr. Justice Rahim, and this would cover both the allegation of actual but also presumed undue influence, is that he evaluates the evidence and concludes at paragraph 74, at page 304, that the court finds, therefore, that there was no undue influence in the circumstances the conveyance was a valid one, that having followed his evaluation of the evidence that he had of the medical state of Ramnarine around 2006 and the fact that he was capable of conducting his own business. So the trial judge, on having heard the evidence, makes the factual finding that there was no actual undue influence. And that is an answer in my submission both to an allegation of actual undue influence and also presumed undue influence.
Does the judge say there was simply no relationship of trust and confidence?
I think the conclusion that he reaches is that there was no trust and confidence reposed in him in relation to his business dealings, and that he did his own, Ramnarine did his own thing, as it were, in relation to those.
Well, is it that? I mean, you're right. He does say in 63 that claimant failed to prove that the grandfather had reposed trust and confidence in any of the defendants in the management of his financial affairs. So he makes that finding, notwithstanding the evidence about the power of attorney which he granted to his grandson. But do we read what you've referred us to in 74 as being a repetition of that, or rather his sort of end conclusion of whether or not, looked at globally, taking those matters into account, the allegations of undue influence have been made out?
I'm sorry, I don't quite follow that.
Well, if there's a relationship of trust and confidence, as I understand the law, that simply sets the scene for then an examination by the court as to whether or not that relationship has been exploited.
Yes. And
the test, or one of the tests for that, is whether the transaction which results from it is, Lord Nichols doesn't like the word disadvantageous, but I'll use it as a shorthand.
Yes.
Now, if you've got those factors present, then it throws the burden on the party seeking to uphold the transaction to show that it was the product of the free will of the person in question.
Yes, and my lord, yes, and there are two ways of establishing that free will. The one that's most commonly thought to be the way to rebut that is independent legal advice of an appropriate level. So we have that in Dr. Seepersad, and I'll come to. But the second is that isn't the alpha and omega of rebutting that presumption if one can show on the facts that in fact there was no actual undue influence perpetrated on the facts. And in this case, because of how the undue influence allegation is advanced as a sort of halfway house between a presumption and an actual relationship of ascendancy, the factual material is looked at by the judge, and he concludes, having looked at the material, I would submit, that there was no undue influence, quite independently of the involvement of Dr. Seepersad.
Could you help me with it? I beg your pardon. I do apologise. Just before you go to that, and forgive me if I've missed this in your submissions, but in paragraph 89 of the Court of Appeals judgment at EF 599, they have in mind some evidence to the effect that Kieran had boasted that he was the boss of all Mr. Maharaj's business.
Yes.
Does that have a foundation in the evidence?
There is foundation in the evidence of that, in the sense that that features in the witness statement of the respondent, and it is the subject of a hearsay notice, and it is then not referred to in any of the evidence before Mr. Justice Rahim, before appearing, I think, in some written submissions. So that allegation, the boastfulness of Kieran, that is recorded by the Court of Appeal, is the subject of a statement in the witness statement of the respondent, is the subject then of a hearsay notice, but is not explored with any of the witnesses.
So it was not put to Kieran in cross-examination?
I've done a search term on boss to just check that I wasn't missing it, and I have not found a single reference to that in the record of the evidence.
Is the extent to which a transaction calls for an explanation relevant to one's conclusion about whether there was some kind of relationship of trust and confidence? I ask that because one can imagine some transactions as being so abusive that even if you haven't got any evidence of a prior course of conduct where trust and confidence reposes, it's difficult to think of any other conclusion for the transaction. I'm asking it because, of course, the judge approached all this on the basis that father owned the property.
Yes.
But if father was actually effectively a trustee of the property under with fiduciary powers under power of attorney, the transaction's all the more extraordinary.
Well, my lord, the problem with all of this is that one might think that the more natural way of thinking of it would have been that there was some influence exercised on Ravi, by which I mean that all that's happened is that Ramnarine has, for reasons that I wouldn't wish to speculate about, entered into this transaction. And the question really is, rather oddly, on the assumption that you're against me on the beneficial interest point, that a trustee, an implied trustee, has agreed to deal with a trust asset in the way that you describe, my lord. But the problem with that then is one still has to show that the trustee's will was overborne, and one has to put out of one's mind procedurally that perhaps there would have been other chapters of Lewin on trusts that would have been applicable to Ramnarine's conduct.
Or just that he needed no encouragement.
Or just that he needed no encouragement.
Yes, okay.
I mean, the problem here is that the judge's para 74 is a very brief statement of his overall conclusion after he has said, for reasons that maybe we don't need to go into, that the transaction, the 2006 conveyance was not a transaction which excited suspicion.
Yes.
Now, if that analysis is right, then the two components that you can see set out in Ettridge aren't there. And wouldn't have been there even if the judge had said, well, there was a relationship of trust and confidence. The problem with his treatment of the suspicion, the second element, is that he looks at it through the wrong lens, because he's looking at it on the assumption that the property belongs to the grandfather and not to his son.
Well, my lord, what I'd say about that is this. We are looking at two separate things in relation to undue influence. Now, first of all, relationship. Secondly, one can then look at whether there was undue influence on the evidence as a matter of factual actuality. And then secondly, whether one can infer undue influence on the basis that the transaction was so manifestly disadvantageous on the hypothesis that's put to me. Now, I say two things about that. The first thing I say about that is that, yes, the terms of a transaction, as we know from Ettridge, put you on notice that there's something to be investigated. But the judge covers that off, if you're against Mr. Justice Rahim's decision on that point, by exploring whether or not there was actual exploitation, and he takes the view that there wasn't on the facts as he's found them. And the second point is that the question of the advantageousness or not of the transaction, on the hypothesis that you're against me on the beneficial interest point, one has to ask oneself, disadvantageous to whom?
Well, disadvantageous to father, because he laid himself open to a pretty unanswerable allegation of breach of fiduciary duty.
But
assume that's been dropped as a separate route home.
Yeah.
The facts remain the facts, that he apparently disposed of his son's beneficial property for 1/10 of its value without asking him.
Yes, but then the evidence of Dr. Sipasad is that this was discussed and that he proceeded anyway.
Yeah.
So if
not
again,
discussed with his son.
No, but his son, of course, is not, as it were, party to the contract that we're looking at to set aside. So that's the difficulty. That's the oddity about having fixed on undue influence here, my lord.
May I just ask you to have a look at page 428 of the transcript, not of the transcript, of the bundle, the electronic file. This is the passage in which Kieran is being asked questions by Mr. Coilas. And about halfway down that page, he's asked, at the end of the day, you were the person who principally would have been involved with your grandfather in terms of any transaction that he was dealing with concerning his properties, yes? Mm. And just above that, you would have lived with him and you would be the person who would be responsible for taking him or talking to him about in terms of getting his business done. Answer, yes. Is it possible that's what the Court of Appeal had in mind?
I don't know, because the way I read taking him about was ferrying him around. In other words, he was frail, and he was the one who's actually brought, Kieran was the one who brought him to Dr. C. Prasad's office, for instance. That's how I had read that. And Kieran does say elsewhere in the transcript that as far as he was concerned, Ramnarine was the person who knew all about the business and who was the person who he looked up to for his business dealings. So I'm not sure the Court of Appeal did have that in mind, and certainly that wouldn't have reflected the totality of the evidence.
But I mean, the judge at 72, para 72, page 302, asks himself, or puts, he says there's nothing suspicious in a grandfather selling his land at an undervalue to his grandchildren. Well, indeed, you don't have to express a view about that, but that's not the scenario, if we're against you on the first point, that we're dealing with.
If you're against me on the first point, that isn't the scenario you're dealing with, but you're still, I would respectfully suggest, looking at the mechanics of how this transaction came about. And if, in those circumstances, the evidence that was led in the course of the trial was to the effect that it was said that Ramnarine had been psychologically influenced by Shakuntala and or Kieran, that is evidence that was heard by Mr. Justice Rahim, and he rejected it. The fact that Ramnarine might have been selling a bare legal title or something in breach of his duties as an attorney or something of that nature is, yes, a different factual constellation, but it doesn't go to the question of whether he had his will relevantly overborne, because that is the subject of a separate consideration by Mr. Justice Rahim, I would say.
Well, Mr. Radley, you've no doubt been looking at the clock like me.
Well, can I just ask one thing?
We've got another one.
On a slightly different tack, you say that this point arises if you're wrong on the first point. Can I just explore this as to who benefits from whatever combination of results we get on the first and second points? Now, if the transfer in 1976 was effective to transfer to Ravi the whole legal and beneficial ownership, then that is what was then transferred by Ravi via the power of attorney to Ramnarine in 2006 to the respondents. So they then get, unless that is set aside because of undue influence, they then get the whole of the legal and beneficial interest transferred to them by Ravi.
Yes.
If, in fact, all Ravi had was the legal ownership and the beneficial interest had remained with the father, yes, I don't see then, or I don't quite understand what your case is about where the beneficial interest then lay. It seems to have been assumed that somehow that was also transferred from the father to the Singhs, but I haven't seen a document that purports to do that. Is it your case that undue influence or not, all that was capable of being transferred to the Singhs was Ravi's legal title, so the beneficial interest, what stayed with the father and descended to his two children on his death, or?
My lady, no. What I would say is that this was a sale,
yeah,
and
money changed hands.
Money changed hands.
So we don't know where it went.
So we don't know where it went, but there was an obligation to pay the money, and that would be a full beneficial sale. So essentially, what would happen would be that if one were to put on one's theoretical legal spectacles,
please do,
one would see the legal title passing through the power of attorney and the release of the equitable interest or the transfer of the equitable interest that Ramnarine had passing title to the Singhs. But the sort of, in inverted commas, worst case scenario is that it would have if somehow it had remained in Ramnarine and not passed, it would have devolved through his estate.
But that was split between his two children.
So, but the long and short of my answer to your ladyship is that the exercise of a valid power of sale by Ramnarine would have been effective to transfer full beneficial ownership.
I think the word you're looking for is overreaching, isn't it?
It would have, exactly. Would have attached, the beneficial interest would have, if anything, reattached itself to the barrel of cash.
Yeah.
Because of what?
Because of the overreaching process in a normal conveyancing transaction, that the beneficial interests detach themselves from the realty and reattach themselves to the proceeds of sale for distribution to the beneficiaries in accordance with their shares.
Yes. I was just about to say that we've taken you over your time through a barrage of questions. Your answers have been of the greatest of assistance, if I may say so, and unless there is anything you're desperate still to say, bearing in mind we've read your very careful case as well, and assume you're sticking to all of it, you probably need to give some time to your opponents.
Yes, I'm grateful for that. The only issue I wanted to raise very briefly is dealt with in the case, which is the role of Dr. C. Prasad, and essentially the only 2 points I wish to make in a nutshell were he was Ramnarine's retained solicitor, and secondly, that in line with the Ettridge guidance, he didn't have and shouldn't be taken to have had a roving brief to turn over every rock in the transaction. He was there to ensure Ramnarine knew what he was signing, and my respectful submission, that obviously, I say he did, but that's the only issue that was burning in my chest, and I will sit there.
Thank you very much indeed.
Thank you.
We're going to rise just for 5 minutes or so and consider where we've reached. So if you could stay online out in Trinidad and wait for our return, we shouldn't be too long. Mr. Coilas.
Thank you very much.
Before you start, we've considered where we've got to, and we don't need to trouble you on the first issue. That is the question whether the original transfer in 1976 transferred the beneficial interest in the property to the 2 children. We only wish to hear you on the second issue, which is, I think we can conveniently label the undue influence issue.
Thank you very much, dear Lady, my lords. I had spent quite some time on that first issue, but I'm happy to hear what you have said in relation to it. Now, if you would allow me, there was the concern with respect to whether Iran had actually gone and proclaimed to Ms. Enal that he was the attorney of Ramnarine and she was to leave the property. My friend did refer to it in relation to the hearsay notice. Now, the very first point I want to make on that is that it was never put to Ms. Enal during the course of the trial that that did not happen. So that the fact that it was in through a hearsay notice and no challenge was made to it, the Court of Appeal would have been right to be able to rely upon it in relation to Kieran's use of the power of attorney. More than that, while my friend's researchers did not help him in finding the evidence, if I may point to the evidence at page 442 of the electronic bundle, it may be of some assistance. I had put to Kieran, you acting for power, for her to stay in the property wasn't to get out. But I must say that the transcript says things in a way that didn't quite happen in the court. The point I'm making is that you went there under the power of attorney because power was the effective owner of that property and you had his power of attorney. Yes. So that He said, even slightly before that, I'd asked him, is it not true that when Ravi was murdered, you went at the property with a power of attorney, saying that you are acting for Pa, and she must get out of the property? And then he says, I didn't say to get out of the property. So that there is evidence that Kiran, in fact, had acted under the power of attorney in relation to his presence at the home after Ravi's murder, seeking to eject Miss Enal from the property.
Is this the Chatham Street property?
I beg, the Shakuntala Street property, yes.
That's what you're addressing us about? That's what this evidence is about, yes.
The evidence is about the Shakuntala Street property, but more relevantly, it is respect to the concern that had been expressed in relation to the Court of Appeal's use of the evidence that Kiran was seeking to get Ms. Enal out of the property based on his power as an attorney of Ramnarine. That is the issue that I'm trying to address. My friend was saying that he couldn't find any evidence in the transcript in relation to anything concerning that. So I'm pointing that out as the evidence upon which the power of attorney was being used by Kiran. Yes? Now, in relation to the undue influence, again, my friend had said that the case was presented on the basis of actual undue influence. Now, that is not entirely correct. If we were to look at the judge's ruling at page 293 of the electronic bundle, the judge himself recognized that the case was one of presumed undue influence. And he dealt with it on the basis that, let me read, in cases of paragraph 37, in cases of presumed undue influence, we must establish the existence of a relationship. And he speaks to what the law requires with respect to presumed. Just before that, at paragraph 36, it's clear. It was submitted on behalf of the claimant that the claimant's case was one of presumed undue influence. This was accepted by the defendant as the basis upon which the claim appears to have been put. So it is a mistake to say that the case was run contrarily on the basis of actual and not explicitly in relation to presumed. The case was, in fact, conducted on the basis that there was a presumed undue influence. And the reason for that was that Ramnarine had always been secreted in the bosoms of the appellants at their home for some 8 years, as from age 83 straight to age 92, so that it would have been impossible on the part of the respondent to have evidence of overt acts of pressure. It is on that basis the case was conducted through the lens of a presumed undue influence. Now, apart from that, my friend did criticize that there might not have been focus of attention by the judge in relation to the power of attorney. But this ignores altogether that the very pleading in the statement of case of the appellant, that was very prominently displayed as one of the particulars of undue influence. If I were to take you to the electronic bundle, page 17, under particulars of undue influence, Roman numeral 6, it's particularized. The second defendant was the attorney of the deceased attorney under a power of attorney registered as number and acted on his behalf in all of his affairs. And the first defendant, his daughter, and a copy of the power was attached. So it cannot properly really be said that the existence of the power of attorney and the fact of Kiran's appointment by Ramnarine under the power of attorney wasn't a feature of the evidence that the court had to consider. More than that, the power of attorney was a document that was admitted into evidence. So it wasn't simply a matter of having the power of attorney pleaded, not relating to the evidence. It was a matter of the power of attorney actually being before the court, so that the court would have been in a position to understand the extent of the powers that had been granted to Kiran by Ramnarine in relation to his affairs. In my cross-examination of Kiran, just to put it beyond paraventure, I did ask him, "You are the attorney of Ramnarine?" And he said, "Yes." Now, further than that, I questioned him in relation to his use of the power of attorney, and he would have given evidence that he would have used it in relation to meeting with lawyers, in relation to dealing with past business, so that it is not accurate to say that the power of attorney was not a feature of the evidence, prominently so, with the judge's consideration of this issue relating to...
So are there particular references in the transcript that you wish to draw to our attention?
I beg your pardon?
Are there particular pages in the transcript of the evidence which you'd like to refer to us in relation to that point?
Yes. If we look at electronic bundle, page 111, and I'm looking at Kiran's witness statement for the moment.
Did you say 111?
111.
Yeah.
Yes. Paragraph 4.
Whose witness statement is this?
Kiran.
This is Kiran's witness statement.
Yeah.
The deceased initially handled all his business matters. As he grew older, he began to give me the responsibility to deal with the tenants, businessmen, lawyers, and the doctors, etc. At one time, many attorneys in San Fernando acted for the deceased, but in 2000, Dr. C. Prasad was our main legal advisor. I had a power of attorney to act for the deceased. So it actually comes out of the mouth of Kiran that he was operating under this power of attorney to attend to Ramnarine's affairs. It is not perhaps an irrelevant concern that if we are to do the timeline, the power of attorney was given to Kiran in 2004, and that coincided with Ramnarine removing from his daughter's home and going to live with Kiran.
Do you rely on that? I beg your pardon. Do you just sorry to interrupt you? Could you go back to paragraph 2, please, on page 110 of the bundle, the electronic file? Yes. There's a paragraph, a passage in the middle of that paragraph. As I grew older. Do you rely on that sentence?
Yes. Yes. As I grew older, especially after I finished my degree course in economics at the University of the West Indies, my grandfather and I developed a close relationship of love, understanding, and trust. Now, bearing in mind further within that paragraph, he speaks to suffering an accident, and as a result of that accident, not being able to work. And during this very period, I think it's about 2 years, he was able to develop an even closer relationship with his grandfather based on having to be at home. I remember him asking me to take him to Barapur. Let me just get to that particular point. As I was not working during this period, 1999 to 2001, following a motor vehicle accident, I had more time to spend with my grandfather and grandmother. So that what we are seeing here is an individual who is very closely connected to a grandfather, living with the grandfather for a total period of 8 years. That is to say, from 1998, when Ramnarine went to live at his mother's home, where he was a member of the household. And from 1998 to 2004, and then having his grandfather solely under his care and management from 2004 to his death in 2006. So this is a very important aspect in relation to this question of trust and confidence, which I'll come to in a short moment. In my cross-examination of Kiran, if we look at the electronic bundle, page 428, I asked, but it would be correct to say that you would have lived him and you would be the person who would be responsible for taking him about in terms of getting his business done? Yes. In fact, at the end of the day, you were the person who principally would have been involved with your grandfather in terms of any transaction that he was doing concerning his properties. Yes. So that background tells us that there is a close connection, that there's a close connection in terms of the management of this 89 living to 92-year-old man, and that in itself would have given rise to a relationship of trust and confidence. Now, if I were to look at the judgment of Justice Rahim, which I say is particularly there as to treatment of this relationship of trust and confidence. Yes. Now, at paragraph 62 is at the electronic bundle, page 299. Page 299. I will start at paragraph 62, and I will proceed straight to paragraph 63. The court there says, the court is of the opinion that the claimant has failed to prove that there existed a relationship at the time under which Maharaj generally reposed trust and confidence in the defendants. Now, it appears to the court that there is no reliable evidence coming from the claimant that at the time of the conveyance, Maharaj was bound or beholden to his daughter for his general care and support. We haven't challenged that. We have left that alone. But the fact of the matter is that in the course of dealing with relationship of trust and confidence, this is what the judge says at the end of that paragraph. However, the claimant has failed to prove to the court that it is more likely than not that this was the case at the time of the conveyance, which is the instructive time for the purpose of this claim. Noteworthy in this paragraph is that the learned judge never made reference to Kiran. He never spoke in terms of a relationship of trust and confidence coming about through the living arrangements and the dependency of Ramnarine. Is it cut off? Beloved, are you hearing me?
Yes.
Oh, I'm sorry. Yes, thank you. Yes. He spoke only of Shakuntala. And in speaking of Shakuntala, he identified the relevant period as at the time of the conveyance. Now, where was Ramnarine living at the time of the conveyance? He was living at Kiran. Why then did the judge seek to deal with trust and confidence in relation to that dependency relative to Kiran, who, according to him, is at the time when the actual 2006 transfer was done? So that's a significant failing on the part of the judge in relation to treating with the evidence. Now, in addition to that, he goes on to speak at paragraph 63 that in the court's view, applied equally to Maharaj's ability to look after his own financial affairs. Now again, the point that the respondents make is that in limiting it simply to financial affairs, that really was too narrow a focus, because the law has recognized that apart from financial affairs, trust and confidence can be gained in the course of a relationship coming out of a dependency situation relative to a person's everyday needs and management of that person's life. Now, in looking at the question of financial management, the court would have been obliged, in our respectful submission, to look at the power of attorney. The Court of Appeal noted that the trial judge had overlooked and failed to take account of the 2004 power of attorney, which gave broad powers to Kiran over Ramnarine's affairs. If I can take my lady with that particular paragraph, you will find it in the electronic bundle at page 602. Yes, at page 598. At page 590. The Court of Appeal said, paragraph 88, there was evidence before the court that on July 19, 2004, Mr. Maharaj executed a power of attorney by which he appointed Kiran as his attorney. The power of attorney gave Kiran, as Mr. Maharaj's attorney, very broad powers. The power of attorney provided that Kiran, on behalf of Mr. Maharaj, and in his name, may do and execute all or any of the several acts, deeds, and things. And the court actually recites the number of powers, examples of the broad powers given to Kiran by Mr. Maharaj, was to invest his money, the superintend and management of all his lands, to sell and exchange or dispose of any lands, any property, and so that he had. So that the Court of Appeal was correct to find that in the face of such powers, that the boast of Kiran to the appellant that he was the boss of all Mr. Maharaj's business was not without merit. Now, my friend has sought to submit that this is not something that the Court of Appeal was entitled to do, was able to do. I think where that argument falters is that if we look at the authority of Beacon, which I think is the authority everybody is using today, Beacon has made it very, very clear the area where Court of Appeal or reviewing court can enter into the matter with a view towards reviewing, if found necessary, interfering with a finding that is made by a lower court. If I can draw your attention it's in the electronic bundle. The electronic bundle, page 760. All of my friend's authorities quoted in his submission relate to a situation where a finding depended upon the credibility of a witness. But of course, we know the learning on that. The Court of Appeal doesn't have the benefit of the judge of seeing and hearing the witnesses. But be very cautious in terms of approaching any such evidence with a view towards reviewing it. We understand all that. All of the authorities referred to, my friend, relate to such a situation. What it does not relate to, and I refer to paragraph 17, it does not relate to a circumstance where the review is done on the basis of an undisputed document. So there's no question in relation to considering that document as to the credibility of any witness, something that the Court of Appeal would not have the advantage of in terms of seeing and hearing the witness. And the point is made, I'm at paragraph 17, the importance of the part played by those advantages in assisting the judge to any particular conclusion of fact varies through a wide spectrum. From one end, a straight conflict of primary fact between witnesses, where credibility is crucial and the appellate court can hardly ever interfere. My friend is right in relation to that aspect of the matter. But to the other end of the spectrum, an inference from undisputed primary facts, where the appellate court is in just as good a position as the trial judge to make the decision. Now, that is where we are.
I beg your pardon. I beg your pardon. Just before you go on, I haven't got the page that you're reading from. Could you please just give that to me again?
Certainly, it's at page 760 of the judgment.
716 or 760?
760.
Ah, thank you.
760.
Thank you.
Yes.
Yeah.
Yes, I got it. Yes.
Now, once it is that we understand that in this case, we are not dealing with the credibility of witnesses in relation to what the Court of Appeal interference has been, then we understand that the Court of Appeal had the power to look at the power of attorney, to consider it, just as the judge had, but which the judge didn't use, and to arrive at a conclusion that it provided a strong foundation for considering that a relationship of trust and influence had in fact been established on the evidence.
Mr. Coilas, can I just take you back to page 300 again, paragraph 63 of the judge's judgment.
Yes. Yes, please.
And he says, in relation to the ability of father to look after his financial affairs, that the evidence on the part of the claimant has failed to prove, etc., etc., etc. While the court accepts it very often difficult for a claimant to pass muster when it comes to this, it nonetheless is duty to prove it. And the claimant's evidence in this case is devoid of such proof.
Yes.
Of course, the evidence that Kieran made use of his power of attorney was not, Kieran wasn't called as a claimant's witness, was he? He was a defendant's witness, and you cross-examined him.
That is correct.
Page 300.
No. Page 300. Yes.
Paragraph 63 of the judge's judgment.
Yes.
And he twice in that paragraph, he refers to the evidence on the part of the claimant, or the claimant's evidence. What was the...
Yes.
Two questions, really. Obviously, what Kieran said about his power of attorney wasn't the claimant's evidence. That's something that came out in your cross-examination of a defendant.
Yes.
Who produced and I know you annexed the power of attorney to your pleading.
Yes.
It was presumably produced, was it on disclosure by the defendants?
No.
Whose evidence was the power of attorney?
The power of attorney came through the claimant.
Came through the claimants? Okay.
It ended up being an agreed document, at trial.
Yes. All right.
Yes, the point that you have made, that you have pointed me to, reminds me that there's another point where I am saying that the court really didn't consider this matter properly. Now, in the evidence, in the judgment of Rahim J, he said that the only evidence of undue influence came from the claimant. And we are saying that that is wrong. Now, if you look at the electronic bundle, page 296, paragraph 45, that is where we consider that the judge, in fact, actually went completely wrong in looking at this whole issue on the influence. Somehow he felt that seeing it was the claimant's duty to prove undue influence, that the evidence must come from the claimant. Of course, that is wholly incorrect. Evidence could come from either party's side in relation to any item that is a matter in issue in the trial. And the judge was obliged to consider that the evidence, in fact, took on a wider basis than what he considered. Now, we say that the trial judge fell into error and that there was relevant evidence coming also from Shakuntala and Kiran, and that such evidence related to Ramnarine's living arrangements from 1998 to 2004. Now, you will get that the electronic bundle, page 110, paragraph 1 of Kiran's witness review. I can't get it. Yes. Paragraph 1, he spoke about, if you go down 3 lines from the bottom of the paragraph, my grandfather, Ramnarine Maharaj, lived with us from 1998 to 2004. Also, we could find it at paragraph 2, which we have already dealt with in terms of the close and loving relationship. Again, we see that Ramnarine's reliance on Kiran for its social, medical, and legal affairs was also something that the court was obliged to consider as falling within the parameters of the consideration of trust and confidence. If we look at the electronic bundle, page 111, paragraphs 4 and 5, I have referred to that in relation to the power of attorney. I would go to paragraph 5. Well, he is taking him now to the Southern Medical Center, where he underwent minor surgery. So he is the person who is dealing with taking Kiran wherever it is that he has to go. And I think that we could also find it at page 428 in the cross-examination of Kiran. Because to show the closeness and the involvement of Kiran with Mr. Maharaj in relation to trust and confidence. Page 14. Okay, so this is where we spoke about he's the person who's dealing with all of his transactions. Well, we see as well that the relationship itself of grandfather and grandson, while it is not a situation raising the irrebuttable presumption, was a factor that the court also had to take into account. It was wrong for him to say that, listen, you know, the evidence, all the evidence with respect to the attempt to prove the influence was to come from the claimant. We see as well that Ramnarine's age and his feeble condition was relevant to the question. So, having regard to the fact that we are proceeding on the basis of presumed undue influence, we accept that we had to prove a relationship of influence and that there was a transaction which called for an explanation. In relation to that first element of proof, we say that the Court of Appeal was entirely correct to consider and deal with the power of attorney, because it was a material aspect of the matter which the trial judge failed to consider, and that based on the existence of that power of attorney, standing for such a long period, between 2004 to the man's death, this would have shown that there was a relationship of influence by Kiran over Ramnarine. It certainly would have reflected the reposing of trust by Mr. Maharaj in Kiran in relation to his affairs and in relation to his treatment of him in terms of the management of him during his old age. On that basis, we see that the judge was entirely wrong to conclude that proof was not given an acceptable standard as to the existence of a relationship of trust. I will move on now, or before I do so, I should simply say that we have cited an authority of Hackett and the CPS, where the judge in that case found that the appointment of a person as one's attorney involves a relationship of influence. If I can simply refer to that particular judgment, it's at the electronic bundle, page 1326.
I'm sorry, could you get the page again?
It's electronic bundle 1326.
Thank you.
Paragraph 54. Just have it. Paragraph 54. Not surprisingly, and quite correctly, Mr. Fletcher accepts, as I would have inevitably found to be the position, that there was such a relationship, he's referring to a relationship of trust and confidence. Because in June 2003, the claimant signed a power of attorney in favor of her son, namely the second defendant, and this meant that there was a relationship of presumed influence between the claimant and the second defendant. Now, a further reading of the case, there will be certain similarities in that we are talking about an old person, a mother who gave a power of attorney to her son, so that there is, as I would expect, a very simple proposition that you would not really give a power of attorney, even here in Trinidad, to a person that you don't have trust and confidence in. So that the mere existence of the power of attorney and the fact that it was operated on by Kiran, without complaint it would have appeared, by the grandfather, proved a relationship of trust and confidence. Now, it is certainly a ground for the Court of Appeal to interfere, where a judge fails to give any regard at all to material evidence that touches on the question. So that, again, I continue to repeat that this is not a situation in relation to a consideration of a matter involving credibility or reliability. It is documentary evidence that is fixedly before the court as an admitted document, which the court, that is to say Rahimji, failed to take into account, not even mention it in his judgment dealing with the question of financial trust and confidence. We are talking about a multi-millionaire in Trinidad giving a power of attorney to a grandson who operated under the power of attorney. In fact, there's evidence from Kiran that the monies that he gathered up, the 400,000, to pay for the transfer under the 2006 transfer, came from rents that he was getting from properties that was owned by his grandfather that had been transferred to him. So that it is our respectful submission, almost irrefutable, that the judge had, it was impermissible for the judge to come to the finding that there was not a relationship of trust and confidence based upon the evidence that we have sought to give. Now, so that the next question that had to be proved by the claimant was that there was a relation, that there was a transaction which called for an explanation. Again, Rahimji dealt with that question on the basis that the property belonged to Mr. Maharaj, which we have now come to the conclusion was an wholly erroneous basis for dealing with it. But I still want to go into it because it shows how the judge was simply not getting it right, respectfully. In dealing with that, whether the transaction called for an explanation, the judge referred, perhaps I should refer to how he dealt with it. You would find it you would find it at page 30. Yes, at page 301 of the electronic bundle, I'll go straight to paragraph 68. There's nothing in the circumstances surrounding the transaction that will give rise to any suspicion calling for an explanation. Remarkable statement. Now, how does he go there? The judge started to refer to money being handed over by Maharaj. He goes into the question that when Dr. Sipasad asked Maharaj if he counted it, it was alleged that it was done in the car. So that what we find is that the judge is referring to things that really have no real connection to the question that he was looking into. He's speaking about relating to monies handed to Ramnarine, that he was an experienced businessman, so he could count $100,000 while traveling in a motor car going to Port of Spain. I can tell you that from San Fernando to Port of Spain is a considerable distance. And there's evidence that Ramnarine didn't like traveling. He didn't like traveling in motor cars. But the judge was willingly going along accepting that a 92-year-old man is counting 100,000 Trinidad and Tobago dollars while going up to this trip to Port of Spain. The judge even considered that Kiran carried the surname of Ramnarine, which of course is entirely wrong. It is Kiran Singh, and this is Ramnarine Maharaj. So only pointing all of this out so that the judge was just misguided in relation to how he approached this question of a relation of the transaction calling for an explanation. At the end of the day, the court expressed the view that the transaction did not call for an explanation because a sale at an undervaluation is consistent with the sale being made to a family member and not a new. Now you would find that
Can you,
paragraph 72.
Mr. Collas, can you help us on the undervalue? It's said by your opponents that actually the evidence of undervalue wasn't very satisfactory. The judge seems to have been prepared to assume there may have been an undervalue, but said that it wouldn't matter anyway in a family transaction. That's paragraph 72, yes. Isn't it?
72.
At bottom of page 303. But it would help us just for a little summary, if you could, of what the evidence about undervalue was and whether it was challenged or whether there was any evidence to the contrary.
Well, answering the second first, there was no evidence to the contrary. There was no evidence to the contrary. The evidence in relation to the value came from a well-respected and highly recognized valuator, Roy Guman Singh. There was no evidence by the defendants as to the value of the property, even though it was clearly raised on the pleading that the property was sold at an undervaluation. The defendants did not put in any evidence on their own in relation to any valuation of the property by any expert. More than that, the defendants would have known that the claimants were seeking the appointment of an expert, got the court's permission for expert evidence. The appellants themselves didn't concern themselves with that. And that's a very important aspect of this case, please, my lord and my lady. This entire case took on, a form of its own at the trial itself. Because at the beginning of the trial, having regard to the documents that were filed, it was already accepted that the property, in fact, had belonged to Ravi, which we have now come to the conclusion of. And that the issue then was whether the sale was a sale at an undervaluation. Now, at trial, there would have been the cross-examination of Mr. Gumansi by the defendant's attorney. But at the end of the day, nothing came of it. He was simply suggesting to the witness that his valuation exercise didn't take into account the fact of different properties along the street, nothing that the expert was not able to handle and to give an explanation of as to how he arrived at the particular figure. More than that, the court itself, in its judgment, proceeded on the basis that Mr. Gumansi's evidence was acceptable. If I can refer to the court's ruling, where he dealt with the evidence of the witnesses. It is to be found bear with me, please.
He does refer to the evidence at paragraph 77 without comment.
Thank you so much. I was so Tab 6. Paragraph
77.
77. Yes. Yes. While the evidence of Roy Gumansing was that the disputed land had been valued at 5.5 million in January and sold at an undervalue for 500,000. There's no direct evidence from the claimant of Maharaj's mental ability. But there is before that, please, Malad, where he is dealing with the evidence of the different witnesses, where he referred to the evidence of the witnesses. I'm just trying to find it quickly. It's at paragraph 45, page 296 of the electronic model. Yes, it simply says, given evidence in the claimant's case was the claimant herself, Roy Gumansing and Madam Rajkumar. Roy Gumansing is a chartered valuation surveyor and gave evidence of the value of the land at present and in 2006. So that there is no comment, no observation, no criticism in relation to the valuation that had been received from an expert.
Thank you.
As Malad has correctly pointed out, at paragraph 77, he has referred to the evidence without making any criticism or any indication, given any indication that that evidence is not accepted. So that is what we have in relation to the value of the property and the undervalue at which it was sold. The Court of Appeal, in dealing with this whole question of whether the transaction raised call for an explanation, said that that was material evidence upon which the transaction obviously called for an explanation. In dealing with that, the court expressed that a transaction is one that calls for an explanation according to Ettridge. If the gift is so large, and I am at the electronic bundle, page 915 to 916, and I'm referring to paragraphs 22 and paragraph 25. At paragraph 22, it is stated that, this is what is stated. If the gift is so large as not to be reasonably accounted for on the grounds of friendship, relationship, charity, or other ordinary motives on which ordinary men act, the burden is upon the donee to support the gift. Immoderate and irrational are phrases used to describe the concept. It must constitute a disadvantage sufficiently serious require evidence to rebut the presumption that in the circumstances of the parties' relationship, it was procured by the exercise of undue influence. Now, the Court of Appeal was guided by this. I am referring now electronic bundle, page 600, 600. The court identified first the basis upon which it must deal with this question, quoting from that wonderful judgment in Petrich. And the court posed itself the question, paragraph 92. In view of the above, I believe it is appropriate to ask whether the transaction is one that constitutes a disadvantage sufficiently serious, which cannot be reasonably accounted for simply by the parties' relationship, parity, or other ordinary motives on which ordinary persons act. And this is the material point here. Disadvantages in this context refer to disadvantages between the parties, not commercial. And in this case, insofar as Mr. Maharaj was acting as Ravi's agent under the power of attorney, it would need to be established that the transaction was disadvantageous to Ravi. Now, of course, in the context of this particular case, the judge, having concluded that the property belonged to Ramnarine, never really addressed his mind to the transaction in relation to if the property had in fact been Ravi's property. So again, the Court of Appeal was obliged to consider the question based on this different premise. And in considering it in relation to this different premise, the court came to the conclusion that it was a transaction which obviously, based on the undervaluation, called for an explanation. And the court went further, that it called for an explanation because if you look at it from the point of view, not only from the point of view of the undervaluation, look at it from the point of view of the relationship. The court came to the conclusion that there was a strained relationship between Ravi and the beneficiaries under the 2006 transfer. So that in itself as well indicated that it was a suspicious transaction and that the payment had satisfied the prerequisite of showing that it called for an explanation. On that basis, again, we see that the Court of Appeal was right to reverse the trial judge's finding on this question of whether the transaction called for an explanation, and that the Court of Appeal was right to do so based on the fact that we are talking again about evidence which really was, for all intents and purposes, accepted by the trial judge, that the property was in fact worth $5.5 million when it was sold at $500,000. Now, having reached there, the next question is that the presumption would have kicked in. They have proven a relationship of trust and confidence. They have proven that it called for an explanation. The Court of Appeal has accepted that we have proven that. So that the next thing that's to happen, as the Court of Appeal identified, is that the presumption kicked in. Now, let me get to that. Yes. Well, we are at the electronic bundle, page 601, and we are at paragraph 96.
I think I misheard the page number.
Sorry, it's at page 601?
601, thank you.
Yeah.
Yeah, I got it.
Because it is, in view of the above, the presumption of undue influence is raised. There is therefore a presumption that the 2006 deed of conveyance was procured by improper or unacceptable use of the influence held over Maharaj. In other words, there's a presumption that the conveyance was procured by the exercise of undue influence over Mr. Maharaj. The burden therefore shifts to the respondent to provide an explanation for the transaction that is sufficient to rebut the presumption. And the court now moves on to look into the question as to what must be shown to rebut the presumption. Before I go into what must be shown to rebut the presumption, I think there is in Ettridge an explanation as to what is to happen when the presumption kicks in. I think I'll come to that in a while, but I'll continue with the Court of Appeals decision for the moment. Yes. The Court of Appeal identified that what needs to be proven by the defendant is that Ramnarine would have acted only after full, free, and informed thought about it. Now, the question in this case is whether Ramnarine acted with full, free, and informed thought. There's an attempt to say that that could have been achieved through Dr. Stipasad's involvement. Now, the evidence in this matter is that Dr. Stipasad was in fact the attorney for Ramnarine, but that Kiran always had contact and communication with him in relation to Ramnarine's affairs, so that it is not a clear case of Ramnarine having any independent advice, in the sense that the advice would have been connected to Dr. Stipasad's familiarity even with Kiran. Such connection did not allow for the giving of free advice. And we must look at the evidence of Dr. Stipasad. If I can refer. Electronic bundle, page 388. Yes, electronic bundle, please, page 388. Dr. Stipasad is being cross-examined. I'm at the middle of the page.
Can you just help me, Mr. Kaitis, on this? I mean, before we look at this evidence, was this, I didn't understand that, I mean, it was relevant to other issues in the case, but I didn't understand that the defendants were relying on Dr. Stipasad's involvement as sufficient in itself to free the father from any undue influence there might have been, if there was any.
Yes.
I mean, I may have misunderstood that, but that's certainly not the impression I got.
I'm addressing it on the basis that there is some sort of suggestion that because Ramnarine at least had contact with Dr. C. Prasad as an attorney, then whatever influence that he could have been under could have been removed by his dealings with Dr. C. Prasad. There's some suggestion of that. So this is why I'm saying that that suggestion really has no legs, because at the end of the day, Dr. C. Prasad, in fact, almost acknowledged that it didn't really cross his mind that this man could be under the influence of the persons who had brought him to his office. He didn't see it that way. So that there was never an attempt on his part to investigate that question. And he dealt with it as an ordinary transaction where he's told to do something and he's doing it. In fact, I specifically put to Dr. C. Prasad with a heavy hand that he was acting as a puppet and that he was not performing his duties in relation to dealing with Ramnarine in the context in which the transaction had arisen. And of the transaction being the taking away of property from one person, being the man's son, so as to give it to their daughter and grandchildren. So the only point that I'm trying to make here really is that any claim that any influence under which Ramnarine might have been operating, he was freed of it by being in contact with Dr. C. Prasad. I'm saying that that claim only has to be mentioned to be dismissed because the evidence doesn't support it. That is why I was referring to what Dr. C. Prasad's evidence was. But I'm in agreement that it really is a non-issue. And I think in my submissions, I think that I've used the word that Ramnarine was not emancipated from any influence that he might have been under, okay, by his attendance with and upon this Dr. C. Prasad. So that at the end of the day, what we have here is that the property is transferred. There's no proper explanation for it. There's no evidence that it is done through a free and informed mind, so that there is proof then that there is undue influence. That is the ultimate conclusion. No evidence to contradict it. So therefore the evidence stands. And on that basis, the court would have been wrong to conclude that the transaction did not suffer from undue influence, so as to be set aside.
Mr. Cortez, can I just ask you about the money? We were told earlier today by Mr. Radley Gardner that everybody agrees that the money appears to have got as far as Dr. C. Prasad's office, but nobody really knows where it went from there. Ordinarily, if the court sets aside a transaction on equitable grounds, any money paid under the transaction has to be repaid. Did the Court of Appeal do anything about the money in this case, or is the position that since there's no evidence that the money ever reached the beneficial owner, there's no reason why any condition of repayment should be imposed?
Well, let me answer that question this way. It is highly debatable whether any money was in fact paid. Let us look at it from this angle. This money is supposed to be paid and to be paid in cash, as was put to Kiran under cross-examination. That was used as a means of not being able to show a record as to the source from which this money came. The money is supposed to have been put in a bag and taken to Dr. Sipasad's office.
Yes.
Dr. Sipasad doesn't look in the bag. He doesn't trouble himself about that. He just says to hand over the bags. The money is then handed back to Kiran, according to the evidence. Now remember, Kiran is now taking Ramnarine back to his home. And Ramnarine is at Kiran's home. And he is taken in and out of that home by Kiran. In Kiran's evidence, he is unable to say where the money has gone. There's no evidence that the money was used for the alleged purpose for which the property was sold, to give donations. So that at the end of the day, the clearest evidence is that this money never reached Ramnarine, and that very likely that there was really no money. I know that might be taken at fact, but at the end of the day, when you look at the evidence in this matter, the way in which the defendants had approached this matter, the defendants' approach to this matter was to say nothing, to say the least, and to leave it to the claimant to prove what she can prove. The defendant had it in the ability to call perhaps even a caregiver so as to show what was Ramnarine's state of mind, what dealings that she had with Ramnarine, what opinions that she would have formed based on those day-to-day dealings as to his ability. They didn't bother to do that. So that at the end of the day, the appellants really left it to see if you could prove what we all know has taken place. But see if you can prove it. So that to answer the question Mulad has asked, it is my respectful view that the money not having reached anywhere near to a Ravi, then in such a circumstance, that there is no need for any reimbursement by Ravi's estate in relation to this alleged payment of $500,000. The money, at the end of the day, would have been, if we believe Kiran, at Kiran's home. It would have been at Kiran's home with Ramnarine, where Ramnarine has his own room. There's no evidence that the money was taken out of the house, so that whatever loss of the money or lack of explanation as to where the money has gone is really an explanation that involves a responsibility of Kiran to have ensured that the money was at least secure. Now, let me help by quoting from the electronic bundle, page 445. 445.
Thank you.
445.
Yep.
Where I asked him, Mr. Coiles, I am asking, tell me, was the money as far as you, as a man of business, was it ever banked? Not to my knowledge. Where was it kept? At the home? In his room? Do you know what happened to it? No, sir. You have Pa under your care, and Pa ends up dead. At some point in time, you didn't check his room for the $500,000? When he passed away, yes. Did you find it? No, sir. At no time during the course of his having this money of $500,000 did he become aware as to how any of it was dealt with? I can't say what he did with it. You never see him dealing with any money? No. All you know is that money gone, and it never went to Ravi. Now he says, I can't say. And then I question him now if he took him to Ravi and so forth. So that really, this whole question of this money, the whereabouts of this money, the use of this money, the need for that money for the purpose that was allegedly expressed as to given to charity, none of that is there any evidence at all coming from the defendants. So that it is reasonable to conclude that that money that is being spoken about was really just a matter of form. It was just a matter of form. And that really, that there is no money that the respondent should be called upon to pay in relation to any alleged payment of this sum. But in that regard, I'm just reminded that I had questioned Kieran as to this whole question of the purchase price. I had done that because in the deed, the 2006 transfer, the purchase price was expressed to be some $550,000, whereas the evidence that was given is that the purchase price was really $500,000. And I'm referring to this just to show the confusion as to this whole question of purchase price and money. And the eventual explanation was that the purchase price was expressed as $550,000 because stamp duty had to be paid and expenses had to be paid. So all of that was added up and expressed as the purchase price. So that the whole question then of this $500,000, it is really very suspect as to whether monies actually change hands for any length of time or at all.
Thank you.
No. Yeah. Well, a lot of my time has been spent in relation to the first question.
Yes, well, you don't have to worry about the first question, Mr. Twilas.
Well,
you don't have to use up the whole of the time allocated.
Yes, so that well, I don't want to speak unnecessarily on undue influence, you know, just for the purpose of occupying time. So that if there's anything that Milady might want to inquire into relative to this aspect of the case, I am open to responding as best as I can. But it is my submission, with regard to what has passed, that the Court of Appeal was entirely correct in reviewing the transaction, coming to the conclusion that the presumption having arisen, it was incumbent upon now the defendants to do what they have not done for the entire trial, to give evidence so as to explain this transaction. That is what was required of them. They have not done that. There is no evidence that challenges in any way that the transaction was performed through presumed undue influence. That being the case, the only thing that has to be done is to conclude, as the Court of Appeal concluded, that the transaction was liable to be set aside. On that basis, the Court of Appeal proceeded to set aside the transaction, and we see that the Court of Appeal was right in doing that, and that the judgment of the Court of Appeal should be upheld, and that we should be granted cost of this appeal. There is something that is nagging my mind. I will allow the little time that I have, or the great time that I have, to deal with. And it is a statement in the judgment of Ndonka G.A. Where he said that once the presumption prevails, then the only step that has to be taken is to set aside the transaction. Just want to find that. That's exactly what the Court of Appeal did. Proceeded to set aside the transaction. And that in itself would have reflected a finding on their part that undue influence had in fact been exercised over Ramnarine. Bear with me 1 minute, please. Yes. At paragraph 96 of the judgment of the Court of Appeal, page 601, the court did express that in view of the above, the presumption of undue influence is raised. There's therefore a presumption that the 2006 deed of conveyance was procured by the improper or unacceptable use of the influence held over Mr. Maharaj. In other words, there's a presumption that the conveyance was procured by the exercise of undue influence over Mr. Maharaj. The burden therefore shifts to the respondent to provide an explanation for the transaction that is sufficient to rebut the presumption. That isn't exactly what I was looking for, but...
Well, Mr. Coilas, we've reached the end of your allotted time, and that's quite generous, bearing in mind you didn't have to deal with the first issue. So unless there's anything you're desperate to tell us, thank you very much indeed for your submissions.
Thank you so very much.
Yes, Mr. Radley Gardner.
My Lords, I'll be brief, but it is in my submission important to bear in mind what the course of the evidence was in relation to undue influence, which, after all, was the dispute that the trial judge had to adjudicate upon. In that regard, I would simply refer the board to the electronic transcript at 457 and then at 477, which is the culmination of the cross-examination of Kieran and Shakuntala. Kieran has, before the board, assumed an importance, and his power of attorney has assumed before the board on this appeal an importance which it never bore at trial. The reason I say that is if one looks at electronic bundle 457 and sees the summation of the case that is put to Kieran at 457, what you will see is that the case put to him is entirely based upon actual psychological control over a frail person. And in the course of the questioning between 457 and 458, the power of attorney does not feature at all. What features is that there is alleged to have been a concerted effort to exploit the wedge in the family that Kieran and Shakuntala essentially forced Pa Ramnarine into transferring the property. There's no suggestion at all in the evidence put to Kieran or Shakuntala that the power of attorney played any role whatsoever apart from sitting in a drawer effectively until it was used by him after the death of Ravi to visit the family in the separate property to which my learned friend drew attention. And I say that is relevant because the power of attorney needs to have been shown to have had some sort of causative role to play in this, I would suggest. But be that as it may, I would also remind the board that once the presumption of undue influence is raised, if it is raised, there is a range of evidence that can be called in order to rebut that, not limited to, of course, independent legal advice. That follows from what is said by the board in the Naraya and Bin Omar case, the passages in the electronic bundle at 797, which says that it is necessary for the donee to prove that the gift was the result of the free exercise of independent will. And the board there noted that one way of showing that is advice, but that's not the only way. In our respectful submission, as we can see from the judgment of Mr. Justice Rahim, there was plenty of evidence to suggest that when Ramnarine was acting, he was acting of his own free will. He is described as having had knowledge and understanding of the transaction as a property developer by Mr. Justice Rahim at paragraph 72 of the judgment when he discusses the visit to Dr. Sipasad to give effect to the transaction. So there was evidence there, and as I've outlined in my earlier submissions, that negated the suggestion that Ramnarine was acting under undue influence in 2006. The relevance of Dr. Sipasad is also that, as has been noted in passing, is that in the Ettridge appeal, at paragraph 61, the Supreme Court pointed out that it isn't the function of a solicitor to veto a particular transaction. It is the function of a solicitor to ensure that the import of a transaction is understood. And the findings of Mr. Justice Rahim in that regard are that the meeting did result in Ramnarine understanding the import of the transaction he was entering into. The law does not require the solicitor, as I've referred to before, to, under a roving brief, try and give advice beyond his instructions or safeguard, if they needed to be safeguarded, the interests of Ravi, who was not his client. So the evidence, I would suggest, is that Dr. Sipasad did ensure, as Mr. Justice Rahim found, that Ramnarine understood what the transaction was.
But not the interests of a person acting under a power of attorney in relation to property beneficially owned by somebody else include an interest in knowing what his fiduciary duty is?
Well, my lord, there's no indication from the evidence that we have got that was something that troubled Ramnarine. In other words, I understand, my lord. Well, my lord, I understand the import.
He appears to have been blissfully unaware of it.
Well, he exercised the power of attorney, of course, and he had, since 1964, had more than one of them. And Dr. Sipasad was somebody who he'd had previous dealings with. Whatever one thinks about the wisdom or otherwise of what Ramnarine did in 2006, there is no evidence to suggest that he did that unaware of or in ignorance of what was going on. Now, just very, very briefly, your lordship asked my learned friend about the valuation, and I do pick that up in the case, so I don't possibly need to go into that in too much detail. But the core of the cross-examination, really the complaints about the valuation break into two categories. Category one is that if one looks at the valuation report at pages 101 to 103 in the bundle, one notices three things. First of all, that vacant possession had been assumed for the purposes of the valuation in circumstances in which we know that there was, at least at that valuation date, a tenant paying rent. So the valuation can't have accurately proceeded on the basis of an unencumbered vacant freehold. Secondly, pages 101 and 103 show that there was an assumption that there was satisfactory planning. And three, there was no indication of what planning potential this site had. So there were three assumptions made underlying the valuation which are demonstrably not applicable to the subject premises for valuation purposes. In terms of the cross-examination, the main cross-examination of the valuer that I would refer the board to is at pages 332 to 333. Essentially what that passage shows is that the valuer attended without his files, without any evidence of any of the comparable transactions upon which the valuer was relying. And secondly, that some of the comparable evidence on which he was relying related to already built-out sites. So he was comparing a bare site with a dilapidated building used for car parking under a lease with properties which had already been fully built out. So that was the challenge, or one of the main challenges. First of all, that he was not comparing apples with apples, but secondly, that there was no evidence to show what the comparables were that were being used. So that's simply to indicate why it was that Mr. Justice Rahim did not explicitly, it seems, endorse that valuation evidence. He referred to it only in passing, and I would submit the Court of Appeal ought not to have reached a conclusion on valuation which Mr. Justice Rahim evidently felt he could not reach. May I just turn to my instructing solicitor
Yes.
and see if there's anything further? Unless I can answer any other questions or assist the board, that's the end of my...
No, thank you very much indeed. Well, we're most grateful to both counsel and to their supporting legal teams for their written and oral submissions on this appeal. The board will take time to consider what judgment it ought to give.